कौन सा ट्राई कर, कौन सा दिला?
आपके इसमें कौन सा ऑडियो चला चेक करो ना, ये मत चलाओ आपके पास कोई ऑडियो है इसमें?
अभी चेक कर।
नहीं है तो
पिन काढून बघ, पिन काढून बघ, लॅपटॉप लावायचे.
ऑनलाइन अजून झाला नाहीये, आवाज चेक करतात.
लॅपटॉपचा आवाज आहे, राहू द्यायला पाहिजे. आवाज कमी करा.
व्हिडिओ बरा त्या बाजूला मला असं ते दिसत नाही. हॅलो Mr. Deepen, can I start now?
Yes, madam.
Okay. नहीं सर मैं अशी भी होते. Can start. Hello. नहीं दिसतंय असं ना? Okay. Okay. Hello. Good morning and welcome to this unique hybrid CME on Save Your Practice. So to discuss all the medical legal aspects, we have gathered here, and I think on online there are about 100 people. They have joined CME. So thank you all. I'll just do some secretarial announcement. So welcome all delegates. CME booking is now online, so you can register. Then register online, download a judicial app from Play Store. So it will be easy for you to join any of the, you can do registration, then join Social Security Scheme of IMA and IMA headquarters. Secure future of your family. You can pay fees today at the counter. So for inquiry, we are all our esteemed members. Today's topic is CME on Save Your Practice. So to say, I will just start with a Sanskrit. Vachanam jnanadam balye tarunye shila rakshakam vardhakye dukkha haranam hitam sadgrantha vachanam. Hitam in attending CME in medical legal aspects, that is to save your practice. So today we are having a CME on Save Your Practice, and all the eminent speakers from Mumbai and Pune. You must be knowing our Dr. Jayan Navrange, so nothing to tell about him. He will be starting the CME today, and Dr. Santosh Kakade will be the next speaker, and Dr. Shivkumar Uttare sir, our MMC president, will be there. So with this, I will just tell about the our upcoming CMEs. So this is on 31st of July, and this is by Brahma Kumari, Regenerating Medical Minds. So the topics are the experience sharing with spirituality by Dr. Ravindra Kutte sir, President-elect, Maharashtra branch of IMA. Values in healthcare, a spiritual approach by Dr. Ashok Mehta. And distress, Dr. Manoj Matnani, and Raja Yoga meditation practical demonstration by Brahma Kumari Sunanda Didiji, in charge of Jagdamba Bhavan. It is at Pisoli on Katras Hadapsar bypass, Jagdamba Bhavan. So you can register with free registration link, and it will be from 9:30 to 2 and followed by lunch. So you can give your names and you can register. We have already published this in our IMA Plus. So with this, the next, as you know, we have UConn on 27th and 28th of August. It's a 12th Maharashtra State Conference of IMA Women Doctors Wing, but open for all IMA doctors. And we are hosting this, IMA Pune is hosting this, and the theme is Women's Holistic Well-Being. And for this, we are having the academic as well as cultural programs along with the various competitions. So there will be a dance competition, there will be a solo singing competition, paper and poster presentation for the students, as well as there will be a recipe competition, rangoli competition, and painting and photography. So various competitions will be there along with essay competition. The topic is domestic violence, a social disease. Effects of environment on a woman's health. It will be for our registered IMA members. So see, these are the Go Girls is still, it is going on. It is online. You can download the Astrava app and you can start. To join the IMA, please fill up the 3 forms and sign at 2 places. And you have to attach MMC's registration certificate and marriage certificate for the ladies. And for the this from 1st of April, the charge, the fees are for single 15,700 and for the couple 23,715. So thank you. With this, I think I will call our president, Madam Dr. Meenakshi Deshpande, who is also a medical legal expert. One of the medical legal expert, and she is doing LLB. So we are having today all medical legal people here. Yes.
Yeah, thank you, Dr. Alka. And I welcome you all for this CME. I would just like to start my president's address with one important thing, that we have crossed 30 years today for our medical legal cell. And hats off to Navrange sir and Behre sir, the stalwarts who are sitting in front of me, because they had got that sense of vision to start it in 1992. And of course, they have solved many cases. Like just now, Behre sir was telling me that they used to have 1 case every 6 months. And now I think we are getting 1 case every 6 days. Isn't it right, sir? Correct. So that is the value of medical legal education. And that is also the value of medical legal knowledge which we are imparting today. And I think many of you, whoever have not joined as yet, please encourage your friends to join or come physically, because we have sent this link to nearly all the members of IMA Pune, whoever are there on the WhatsApp group, whoever are there on the email group. So please join, search, and encourage your friends also to join for today's CME, because we are having none other than Utture sir, who is coming right from Bombay. We are having Advocate Dr. Santosh Kakade, who will be joining us shortly. And we will be having Dr. Akshay Shukla also, and Dr. Preeti Jaikar will be coming from Mumbai to educate us and train us and guide us. One more thing I would like to say is that we have got our NMC regulations and we have given a draft to, we have submitted that draft. So we will be getting the latest information as to what will be happening to our recommendations, our suggestions, and our whatever we wanted changes in that NMC regulations today. We will get an overview of that. I would also like Dr. Kakade to tell us something about the CPA, because we are all going to face a CPA today. Within a very short time, it will be coming to us in Maharashtra state. And we are already facing some issues in that in regards to Bombay Nursing Home Act. So we are going to face many litigations after this also. So we would be really, educated about this. One more thing I would like to say about the medical legal cell is, I think we have tackled, our medical legal team has tackled more than 3,000 cases by now. And even now, more than 5 live cases are going on at present, where people come with a lot of, notes. They come nearly with 2 bags of notes to us. And Naurange sir sits with all of them, goes through them, and offers a proper reasonable judgment, or you can say guidance is given, and that helps the doctors to a large extent. We have seen many doctors going with relief from here, and we are going to take this medical legal cell up and above still more, so that we help more and more people in our practice. One more thing which I would like to state is to request all to join our UCON, which is our conference, state level conference. And we have crossed more than 170 registrations as of now. And we are expecting a target figure of 500. So I would request all of you to join as soon as possible before the rates become too high, because it is at a premium venue of Boat Club. And the venue is an excellent venue with good food, good ambience, and we are getting all people from all over, not only doctors. We are getting accompanying persons also from all over Maharashtra coming and joining over us. Only the teams from Pune are not yet joining. So I would request all of you to join this conference, register fast. We have got the counters open near Kavita. You can contact the IMA Pune office and join at minimum rates today itself. So with these words, I would welcome all our medical legal stalwarts who are here today. And yes, please join and encourage your friends to join today. Thank you.
Thank you, Dr. Meenakshi Deshpande, madam, for your kind words. So now I will request our chairperson, Dr. Subhash Behere, sir, and Dr. Sujit Nilegaonkar to come on the dais. Dr. Subhash Behere, sir, he is well known to IMA Pune. He is a senior general surgeon, founder of medical legal cell of IMA Pune in 1990s. He is a LLB person and trustee of IMA Pune. He was IMA MS secretary and past president of IMA Pune and Pune Surgical Society. So with this, I will tell you about Dr. Sujit Nilegaonkar, sir. He practices nuclear medicine at Dinanath Mangeshkar Hospital. He is a LLB and he has done diploma in medical jurisprudence. So with this introduction, short introduction, I will call upon our first speaker, Dr. Jayan Navrange, sir. None other than the Dr. Jayan Navrange, sir. I think he doesn't require introduction. He's a gold medals at MBBS, DCH and MD and 4th in LLB. He's an honorary pediatrician at Srivatsa, Sasun General Hospital, Bharatiya Samaj Seva Kendra, Dinanath Hospital, Sayadri Hospitals, past president IMA Pune, IIP Pune and IIP Maharashtra, vice chairman medical legal cell, IMA headquarters, helped 2000, just now she said about the 3,000 doctors so far, designed and conducted first medical legal course for IMA, visiting faculty at ILS Law College Pune, competitive 26 marathons, half and full and cycling, donated blood 65 times, recipient of Bertha Holt International Award for Rehabilitation of more than 10,000 family deprived children in last 40 years in USA 2002. He's a recipient of Best India Doctor by Indian Medical Association 2015. This award was given to him by headquarters IMA Pune. So with this short introduction, I will hand over the mic to our beloved Dr. Jan. Okay, I'll hand over to chairman for their remarks. Yes, sir. So तुम्हाला आता कसं बोलायचं? हां. So I'll go from there.
Good morning, everyone. I take this opportunity to welcome you all for this CME and the beautiful dais and stage. The beauty of dais is exemplified by presence of Behre sir and very awaited talk of Dr. Naurange sir. I hope you take many take-home messages from this talk, and we should be having one question and answer session after this, maybe. So we expect a lot of active participation from your part. And with this remark, I would like Behre sir to comment and start.
Hello, welcome everybody. You go to any investment consultant, he will ask you to save for a rainy day. Here, IMA has arranged you to learn medico-legal things on a real rainy day and as well as for your life forever. You take lessons from these lectures and they will no doubt benefit you for all your practice in future. Thank you. I will request Dr. Naurange to start.
Thank you, Chairman, Dr. Behre, and also Dr. Nilegaonkar for a very nice beginning of this session. Can you just adjust the mic, volume and all that? So, right at the beginning, I would thank very much the organizers, that is Indian Medical Association Pune branch, and the main sponsors, namely Apex Insurance Company, not Apex Insurance, Apex Risk Cover Management Company. And they are the people who have given us this beautiful opportunity to have this beautiful screen, and it's called electronic display. And I and Dr. Patil were discussing right now that we should be having this permanently launched, because so many good programs occur over here, but maybe it's a bit delicate thing and a costly thing also. So for main conferences or at least main programs in this hall, we'll be arranging for this. Thank you very much, Mr. Rohit Mishra and all of his team for assisting us to conduct this particular program. And I am aware that more than 110 people are, good morning, sir. Good morning, madam. Good morning. So many guest speakers will be there. Dr. Jayakar has come over here. And soon, I think within next 25 minutes, Dr. Utture, President of Maharashtra State Maharashtra Medical Council will also be coming. And our beloved judge sitting on the Maharashtra State Consumer Forum, Dr. Kakade, will be also joining us very soon. So as usual, I am the opening batsman, and as usual, I am the tail ender also. So I'll be sitting here till 4 o'clock, 5 o'clock, whatever the time goes on. I'll be talking today on the landmark judgments which shape the medical practice, or which have shaped our medical practice. What we are practicing, because I'm a student of 1967 batch. Dr. Behre must be 4 years ahead of me, that is 1963 batch. And what is happening today in 2022, there's a hell of a difference. So not only medicine has evolved, not only the things have gone ahead, but even law has chased us. I'm not saying that they have evolved, but they have chased us. So we have to be very aware. And one of my friends who is no more on this earth, Dr. Mahesh Trupe, always used to say in a nutshell that you should not be just satisfied with medically correct treatment. You ought to be legally correct also. And you have to be proving that particular thing that you have been legally correct. So considering this particular theme, I would evolve next 30 minutes on this dwell upon this particular theme in next 30 minutes. So my topic is landmark judgments. They need not be restricted to Indian judgments alone, but I will be taking up only from Supreme Court or at the most High Court. So once in a while, if there is something which is only so far given by National Commission, I will include, but I will not be considering any judgments coming out from district forums, because they get overturned very easily. So, and they are not reportable also in the main journals of law. So doctor is not a profession. Of course, this is for Happy Doctors Day. I will say doctor, last three sentences, doctor is a passion, doctor is a responsibility, doctor is the last hope of life. And therefore, we should not demand, but we should command the respect. To begin with, I think this thing may not be covered in the subsequent talk, and therefore I am covering it here, that there are fundamental differences between the civil law and the criminal law. The number one is police is a necessary party on the criminal side, and of course, private criminal complaints can also be lodged, but the investigations have to be done again by police. Whereas in civil side, it is usually the private parties, but mind well, maximum number of civil litigations are against the government. So it is not that government is not a party, but they become the respondents in majority of cases. Insurance is not possible for criminal side. If somebody says that we are giving insurance cover for criminal liability, no, they can defend your case. For example, Apex Insurance will be defending your criminal case also. But that is the defense cost. But then whatever penalty is passed on has to be borne individually. Whereas on the civil side, insurance coverage is possible. Thirdly, there is no period of limitation except for very minor offenses. And that too in India, not in other countries. So very minor petty offenses, okay, there is a time limit of 1 year, 2 years, 3 years, etc. But there is by and large no time limit for filing a case as far as criminal liability is concerned, because the basic principle is once a crime, always a crime. So that is what the principle is. Whereas there is a period of limitation on the civil side, because here the another principle comes into action, and that is that law does not want to help the person who is sleeping. So you have to file a case within a stipulated time. In criminals, on the consumer side, it is 2 years. On the civil side, it is 3 years. But then there is a point of condonation of delay. The judiciary is given full power to condonation of delay, because as far as medical cases are concerned, it is taken that after the patient came to know that there is a problem. After they come to know that there is a problem. So for pediatric age group, for neonatal age group, you require to keep the papers for 21 years, because 3 years after the attaining the majority. So that is how it goes on differing. The basic idea of criminal law is it should be deterrent, that if something has gone wrong from a doctor's end, or anybody for that matter, the same thing should not recur. Others should not dare to do it again. It's more a punitive. Whereas here the aim is only compensation. So whatever wrong has been done is to be made good in the terms of money, and etc. etc. So, and lastly, there is something what is saving us, and that is section 304A. I'm sure it will be dealt with sometime later. So please remember that everything which lands up, see, doctors are dealing with life and death. So you have to deal with death and disability resulting from your treatment. That does not mean that you have done something wrong purposefully. You have done it with a consent. You have taken all the precautions. Even then something goes wrong. It can be either misinterpretation. I mean, it can be interpreted as an accident, or it can be a natural course of the disease where it is beyond your control. In that case, 304 is applied, 304A, and that is a saving clause for doctors. And this introduction is only, see, in law and in judges, there is nothing like he's a criminal lawyer and a criminal, they specialize in those things. But then judge is the same. The one who is sitting in the appellate section area of civil can tomorrow come to the consumer, and day after tomorrow he can be on the criminal side. So it is just the same. Law is law. But then just to understand this classification I done in a tabular form. Consumer Act is applicable or not? Yes, very much applicable. There is a sort of a misconception. There was some misconception some time back after 2019 when the Consumer Act was modified, or I would say it has new act has come, in short. Whether it is applicable, because it is not mentioned specifically whether doctors are included or not. And 2019 itself at Port Blair, I had mentioned it from the CWC that it is very much applicable. Now this has been upheld by Kerala Consumer Forum, Kerala High Court also, and later on by Supreme Court also. So doctors' services are coming very, sir, good morning, sir. Please give him a big hand of thumbs up hand. Dr. Kakade, he is a sitting judge on the Maharashtra State Consumer Forum, an extremely learned person, and we'll introduce him later on. So Consumer Act is very much applicable. Consumer Act is very much applicable. So don't say that we are not under this. Now I will start with the judgments. And this is where we will be taking home certain lessons which are practical as of 2022 in the month of July. Supreme Court on 4th of March 2020 in a case, this is not a medical case, New India Insurance Company versus Hilly Multipurpose Cold Storage. This Hilly is not a wrong spelling. It is spelled like that only. That notice period to start. When does the notice period start? Somebody sends you a notice. Somebody means from a court. For consumer, we are talking more about consumer because that is the one which is applicable and it's a thing which is happening day and night, every day to the doctors. That this notice period is counted from the time you receive the notice along with the full set of complaint. So this is the Supreme Court judgment. Many times what happens is the court may be for saving purposes sends only a one-page notice. So we have to demand the full set of complaint. Otherwise, what answer are you going to give? And then the period is only 30 days. You can get only one extension of 15 days, no more than that. No district forum is, now it is called commission. It is not allowed to give any extension. So be very particular. And that is what I would say the take home message is that preserve that registered AD envelope on which there is a postal date so that you can say it might have been dispatched some time back, but I have received it today. You require that 30 to 45 days. And this is very critical that you have to give answer. So this is strict after this new act, and that too in section 13, it has been clarified that it cannot be extended anymore. Second is another judgment which is very relevant, I suppose, and very important, not for much for a very small private setup, but for bigger setups and those who particularly have the mortuaries. What is happening today? Death is occurring, and they request that my son is coming from USA, that please wait for the next 2-3 days, keep in your mortuary. And another death occurs, and there is a cross identification. Usually 70-75 years old person, same beard. This is the description in that particular case. And wrong identification of the dead, handing over somebody wrong body, because the one part of the relative says that, oh, this is our body only. They do the cremation, everything. After 3 days, the other relatives come and it is somebody else's body. And then they create a big fuss. So there has to be tag on the hand, identification. I think the last part is take home message, that identification at multiple levels is required. Number one, at the time of admission, you have to have some identity proof, ID proof. Whenever you are sending for testing, check that whatever label is there on the lab test. Also for surgery, the surgeon should check it again that it is the same person. And or even administration of important drugs, anesthesia, check on the discharge card you are giving it to the proper person, because the papers get changed. Also at the time of, there is one case where the transfer occurred with somebody else's case papers and the death occurred over there, and compensation awarded by both, I'm saying both state commission as well as by national commission, is 25 lakhs. So it is for the mental harassment. आपण काही करू शकत नाही, दोन्ही डेथ झालेली आहेत. Cremation has occurred properly, rituals have occurred, but it is a damage to the psychology of that person. He recent judgments at Mumbai. This is the first time I am mentioning this particular judgment, both of these. And now Indian Medical Council, that is now NMC Act and MMC Acts, and they govern the medical ethics, and ethics covers so much more than law. Sometimes they are at conflict crossroads also. I can just quote one example. The ethics say that no fee splitting is allowed, whereas law says income tax or even GST or any other law does not prohibit fee splitting. Ethics says that every life must be saved even from the time of conception, whereas MTP law says that you can terminate pregnancy. So there are crossroads, but then we have to go by consensus, your own thinking and your own. I can quote several examples, but then if we by and large follow the ethics, the judiciary will be with you. It is only when something grossly goes wrong, the law takes its course as well as medical council comes into play. Remember, ethics is that wide, but rather shallow. Law is this much, but it is very deep. So they have more punitive powers or more corrective powers than ethics, but we have to follow that, both of these. One word of caution. Whenever a case goes against you in State Medical Council, for us it is Maharashtra Medical Council, please, हाथ जोडून मी बोलते, do not appeal to the NMC. It will always go against you. Take it from me. You go to the High Court, that is allowed. Go to the High Court. स्पष्ट बोलतोय मी या डायसवरनं in presence of sir. MMC चा निकाल तुमच्या विरुद्ध जर गेला असेल तर पुढच्या लेवलला हायकोर्टला जा, मध्ये जाऊ नका कुठे. It will always go against. And then the High Court will be always saying की दोन्ही bodies तुमच्या विरुद्ध गेलेत. So there must be something wrong with you. जाऊ नका. Anyway, there is a recent change that NMC has said that whenever the appeal is there against the doctor, we will not be entertaining, we will not be tackling because it is not there in the law. तेव्हा ते बदललंच आहे. The appeal will always be there against in the high courts. These are the saving sections. I am not there to cover all this criminal side, but then remember consent comes under these 88 to 95, where it is a saving clause for the doctors. Now, some of the other important acts are MTP Act, PCP and DT. These are separate topics afterwards to be covered. Tubectomy rules, that's not a law, and POSCO, which is the one which I will just elaborate over here, that POXO personnel, general practitioners, gynecologists, pediatricians, everybody be very careful, because what it says, it is a special law. So it supersedes, whenever special law comes in later in date, it supersedes the original act. So that is how it has superseded the Indian Penal Code. It says that any sexual act occurring below the age of 18, both for males and females, is itself a rape, and it is registrable offense under this act. त्यामुळे with consensus, without consensus, सगळं गेलेलं आहे. Even if child marriage has occurred and a sexual act has occurred, it is a grave offense. And not to inform, once knowing, हे फार delicate आहे. Once you come to know that this such a thing, you suspect even. For example, general practitioner gets a child, female or male, with recurrent urinary tract infections. It could be a child sexual abuse. Suspect at least. And if you suspect, and if some clue is there, we have to inform the police. Relatives नाही म्हणाले वगैरे चालत नाही. You have to inform the police. Information policeला patientला पाठवायची जरूर नाही, काही नाही, just inform on telephone. Okay? So don't miss that particular point that relatives said no. Usually the offense occurs within the family. Kaka, mama, chulta, ate bhau वगैरे असं असतं. So another thing, latest judgment is F form बद्दलची चर्चा आहे ती होईल पुढे आता. त्याच्यामध्ये कुठलीही सुटका सुप्रीम कोर्टने दिलेली नाही. 2019 judgment has come. So you have to fill to the last possible details. Now there is no further discussions about it. Shop Act आपल्याला लागू आहे का नाही आजच्या घटकेला नाही. So I will just make it very short. Shop Act is not applicable to the clinics. It is very much applicable to the hospitals where the number of people employed is more than 10. If it is less than 10, it is not applicable. It is not applicable as per the recent amendments. आता वारे कसे वाहतात ते बघूया आपण. सुप्रीम कोर्टचे जजमेंट आहे. इट इज आता तुम्ही नुपूर शर्माची केस बघितली सगळ्यांनी. त्याच्यावरती 55 जजेसनीच एक पत्रक काढलंय की हाऊ कॅन सुप्रीम कोर्ट गो टू दिस एक्सटेंट अँड पुट ऍडव्हर्स रिमार्क्स अगेन्स्ट नुपूर शर्मा अँड गिव्ह सो मच. थोडक्यात म्हणजे ते खूप त्याचं डिस्कशन झालं. तशा प्रकारचे जजमेंट आहे. त्याच्यात ते म्हणतात की बघा त्याची वाक्यरचना बघा. No refusal of treatment for poor in dire need of any medicine, any emergency modality of treatment or any expert. There has to be balancing between human rights and the commercial gains. Constitutional obligations to treat the poor by any hospital or doctor. State spends on the doctors. म्हणजे ती डॉक्टरची पण रिस्पॉन्सिबिलिटी आहे. डार्क साइड ऑफ सच हॉस्पिटल्स कॅन बी इलिमिनेटेड. हे कोर्टाची आहे, माझी वाक्य नाही आहेत, कोर्टाची वाक्य आहेत. Only by sharing obligation towards the economically weaker section. Delhi, so the Delhi government directives were upheld. In short, थोडं काळजीपूर्वक आपल्याला जायला पाहिजे. No ICU, no surgery. This came out in the year 2017. And we had got for the revision, we means IMA Pune thought of going for the revision petition also in the Supreme Court. And then we had put it to the registrar, and registrar had sent us a letter also that you will require then a full bench, which is going to be very expensive. So we could not. has a direct judgment nahi hai ki no ICU, no surgery. असं जजमेंट नाही. पण सगळं तुम्ही जर वाचलं त्याचा अर्थ असा होतो की why did you go ahead with the hysterectomy when the ICU facility was not there? This is way back a story of 1995. I would just inquire with the senior doctors over here. How many hospitals had ICU that time? What was the concept of gynec obstetric ICU? and surgical ICU 1995. कोर्टाने मान्य केलं आहे, हायकोर्टने, सुप्रीम कोर्टने, की there is no evidence of any negligence on the part of doctors. But had there been an ICU, probably the result would have been different. And to meet the two ends of justice, we give a nominal compensation of 5 lakhs rupees. आणि अशी तऱ्हेची 11 जजमेंट्स माझ्याकडे आहेत की ज्या ठिकाणी कोर्टांनी लिहिलेलं आहे, there is no doubt that the doctor was diligent, there is no point of negligence, but to meet the two ends of justice, whatever has been, आता आपल्याकडे डिपॉझिट आहे, once there is a district forum awards 50 lakhs compensation against me, I want to go in appeal, I have to deposit 50% of that first and then I can go to the higher court. थोडक्यात म्हणजे मला 50 लाखाचं माझ्या विरुद्ध कॉम्पेन्सेशन असेल तर 25 लाख मला आधी डिपॉझिट करायला. आता पुढच्या कोर्टमध्ये काय होतं, ते म्हणतात की देयर इज नो नेग्लिजन्स, पण जे काही डिपॉझिट दिलं ते पेशंटला देऊन टाका, म्हणजे तुमच्या 25 लाख गेले. आय एम वंडरिंग वेदर इन्शुरन्स कंपनी विल एंटरटेन दिस, वेदर दे विल honor our claim. Then you require intermediaries like Apex, where they will be taking the responsibility of paying whatever compensation is there. याला दुसरा मार्ग नाही. मला वाटत नाही इन्शुरन्स कंपनी अशा वेळी देईल, कारण ते म्हणाले निग्लिजन्स नाही, मग कसलं द्यायचंय. पण कोर्टाने अवॉर्ड केले तर कॉम्पेन्सेशन नाहीये, इट इज जस्ट अ गिफ्ट. काय होईल मला माहित नाही, पुढची स्टेज आहे ती, पण दिस इज व्हॉट द थिंग्स आर ऑकरिंग. किती वेळ आहे मला? 10 minutes more. ओके. आता पुढे बघा, backache lasting for more than 1 month, the Delhi Consumer Forum has asked a radiological examination should have been done if the patient did not get the relief in a month. हे बरोबर आहे, बरोबर आहे. The forum concluded an MRI test was also required. Therefore, the doctor has committed medical negligence. Investigation केलं नाही म्हणून. This is what I would give you a take home message. आपलं जे शिकवणूक झालेली आहे, कमीत कमी पैशात, कमीत कमी इन्व्हेस्टिगेशन मध्ये जास्तीत जास्त जासूसीगिरी करायची, म्हणजे डायग्नोसिसला यायचं, आणि देन यू ट्रीट, आणि लागलं तर इन्व्हेस्टिगेशन कर. हे बदला, डोक्यातनं बदला. इन्व्हेस्टिगेट फ्रीली, लेट युअर पॅथॉलॉजिस्ट अँड रेडिओलॉजिस्ट कलीग अर्न मोर. त्या ठिकाणी यू हॅव टू इन्व्हेस्टिगेट लिबरली. आणि अशा अनेक जजमेंट्स आहेत, मी एक नमुनेचं दाखवलेलं आहे. देर आर सेव्हरल डिसिजन्स and this is the landmark judgment. Now this is the one which is not originally Indian, if you ask me. This is mentioned, this is in Hasbury's textbook in 1956. Same has been quoted in this particular judgment, that what are the duties of a doctor. There are basically only 3 duties. लक्षात घ्यायला सोपं आहे. That number 1, decide. ही पुण्यातली केस आहे, by the way, this is from Pune. I have met Dr. L.B. Joshi, and this is the case between 2 doctors, L.B. Joshi and Trimbak Bapu Godbole, दोघे कोकणस्थ. Decide if he will undertake the case. पुण्यातले कोकणस्थ. त्यामुळे असायलाच पाहिजे, पण त्यातनं तत्व घडल्याचे आजही कोट होते. ऑल थ्रू एव्हरी केस इट विल बी कोटेड. That decide if he will undertake, the doctor has to decide whether he will undertake the treatment. So that means he can refuse also. He can refuse. आता तर NMC ने नवीन रूल आणलेला आहे की even if the patient is a defaulter in payment in the past, you can say no, you don't pay me, therefore I don't want to treat you. So that is allowed now by NMC. So decide, but not in emergency. Not in emergency. What is emergency is a different perspective by a patient, different perspective by a doctor, and very different by the judiciary. So decide if he will undertake this case for treatment. Number 2, decide the line of treatment. Decide the line of treatment म्हणजे काय काय येतं ॲलोपॅथी मध्ये म्हटलं तर, इट गोज फ्रॉम हिस्ट्री टेकिंग, एक्झामिनेशन, दॅट इज मेडिकल एक्झामिनेशन, अँड थर्ड इज अप्रोप्रिएट इन्व्हेस्टिगेशन्स. 3 गोष्टी झाल्या. डायग्नोसिस, डायग्नोसिस नंतर ट्रीटमेंट. सो वन्स दे जस्ट से ट्रीटमेंट, इट इन्क्लुड्स ऑल दिस थिंग्स. नंबर 3, टू इम्प्लिमेंट द डिसाइडेड ट्रीटमेंट. आपण एक ट्रीटमेंट ठरवली, पर्टिक्युलरली दिस इज ट्रू फॉर इंडोर केसेस. मग आपण काही प्रत्येक गोष्ट करत बसत नाही, स्वतः डॉक्टर नाही करत बसत, नर्सेस आहेत, तुमचे ज्युनियर डॉक्टर्स आहेत, हाऊसमॅन आहेत. सो टू गेट ट्रीटमेंट डन फ्रॉम देम इज ऑल्सो युअर ड्युटी. सो 3 थिंग्स: डिसाइड whether you will undertake the treatment of that particular patient, decide the line of treatment, and number 3, to implement the decided treatment. Any breach, म्हणजे याच्यामध्ये कुठेही खोट आली, ब्रीच म्हणजे खोट, कुठेही चूक झाली, then it is actionable negligence. ओके. त्याच्यात आणखीन एक ऍड करायचं, देयर शुड बी रिझल्टंट डॅमेज. या 3 गोष्टींमुळे डॅमेज, यातलं कुठलंही एक जर कंप्लीट नसेल, द डेफिनेशन ऑफ नेग्लिजन्स इज नॉट कंप्लीट. I think Bolam's principle I have to mention over here. The law is followed in India for medical negligence is so far Bolam's principle. And that says that law, your actions or inactions will be judged by comparison with the peers. आपल्या एरिया मधले कॉन्टेम्पररी प्रॅक्टिस काय प्रिव्हेलंट आहे, whether you followed that particular standard of care, that is what is Bolam's principle. However, I would caution all of you that it has gone much beyond this. And now Bolam's principle म्हणजे काय, expert opinion. In short, expert opinion. Now the judiciary is required to go by a test what is called as whether this opinion given stands the principle of logic. That is Bolitho's principle. Judiciary will decide whether there was negligence or not, and which is correct, because there can be a skewed opinion also. So Bolam's principle is followed, but it is subjected to the test of Bolitho principle. And next is Montgomery's, whereas this is came in 2016, where they have come to the point that it so far Bolam's Bolitho was applicable to the end result, to the treatment part. Now it is applied to history taking. म्हणजे आपण सेकंड एमबीबीएस शिकतो ना, हिस्ट्री टेकिंग एक्झामिनेशन, देन द प्रॉपर इन्व्हेस्टिगेशन, ट्रीटमेंट फॉलोड, एक्सेट्रा, देन द एंड रिझल्ट, पैथॉलॉजी डन, everywhere it will be applicable. So Montgomery has widened this principle of Bolam and Bolitho. Guarantees are not possible. Don't give guarantees, don't give warranties. That word should go out of your dictionary. No guarantees and warranties in medical field. It is itself called unethical by medical council. So no guarantees and warranties. असे पुष्कळ जजमेंट्स आहेत. VP शांता वगैरे ह्याच्यामध्ये एवढंच दिलेलं आहे की डॉक्टर्स कम अंडर कंझ्युमर प्रोटेक्शन ऍक्ट. Ashwin Patel versus Poonam Verma. This case I will be discussing when Dr. Uttare comes, because I think this is a responsibility of medical council and state medical council not to allow cross-pathy. तुम्ही मी इथे शाउट करून उपयोग नाहीये. तुम्ही मी शाउट करून उपयोग नाही. It is up to them to put it into practice. Otherwise it is going to go ahead. आता इतका मीनस आहे, particularly in smaller places. पण even in Pune, मी आता त्याचे फोटोग्राफ घ्यायला सुरुवात केलेली आहे. MD pediatric, MD gynec, MD, they are doing laparoscopic surgery and saying that Shalya surgeon, laparoscopic expert, and झालेले घोटाळे. So how far we are going to tolerate all this? So I think medical council is shirking away from their responsibility, and this is always my debate. Sir is there. Sir is there. Sir, माझं मत असं आहे, in short, की तुम्ही तक्रार करा. आम्ही तक्रार केली ते केराच्या टोपल्यात जाते. You should raise this point to the Ayush Council. Ayush Council तुम्हाला दाद देत नाही मला माहिती आहे. मग तुम्ही त्यांच्यावर ऍक्शन घ्या की why you are not taking action against these people, because section 2 rule 2A and B says that it is only those who are registered under the state medical council can practice modern medicine. Second section त्यातला असं आहे की those who practice without registration with us will be prosecuted. So why we should not be doing it? Why we are waiting for our complaints? So it is my open request that state medical council should do something. I am ready to give petition for this or put an information ki what actions you have taken to stop cross-pathy in this state. कारण मी हे हायकोर्ट जज बरोबर डिस्कस केलं 7 दिवसापूर्वी. He says that law has not changed. What you have to show is that government may come out with several GRs. Unless and until his name is in the state medical register, he cannot touch ॲलोपॅथी. हे किती पण GR काढा तुम्ही.
Live interruption. How about MMC putting their list of members, registered members on internet?
आहे ना.
So we can check that. And if he is not registered, IMA also can make a complaint.
We should make a complaint. We should go ahead.
IMA we can-
नाहीतर फालतू गप्पा मारल्यासारखं होतंय की क्रॉसपॅथी नाही, क्रॉसपॅथी नाही, क्रॉसपॅथी. But anyway, anywhere the case is going in the court, so far till 2022 July, it is always going against that person who is non-registered with the state medical council. So we thank judges that if our councils are not taking action, they are taking action. Martin D'Souza's case, very landmark judgment to protect the doctors, that it says that there has to be expert opinion, and त्याच्यामध्ये अनेक गोष्टी आणि काय करावं काय नाही पण दिलेलं आहे. Time is short, so I will be just mentioning this particular name, that this is a savior judgment for us, and telephonic consultation ला ह्याला prohibit केलेलं आहे. आता पुढे काय झालंय, टेली कन्सल्टेशन लॉ आलाय. telemedicine rules have come in the year on 29th of March 2020. Why it came? It came for COVID. Pune, it will come in the slide. राज्यसभामध्ये उत्तर दिलेलं आहे हेल्थ मिनिस्टरने की we will not encourage telemedicine. And MMC has also mentioned that platforms should not be allowed. These various practo आणि बरीच येतात ना, ते तर नाहीच. तेव्हा as far as possible telemedicine is to be discouraged even today. So please, whenever possible, don't take much help of telemedicine. It's okay to earn money extra, but then be very careful. Put the what we call disclaimer clause. It has limitations. We have to put that in the disclaimer clause. No prescription without direct examination. Now telemedicine has come. The yellow मध्ये लिहिलंय पण ते पुन्हा बदलत चाललेलं आहे. Kusum Sharma versus Batra, same thing again, but they have given further guidelines की डॉक्टरनी कशी consent घेतली पाहिजे, काय घेतलं पाहिजे वगैरे. Harjot Singh Ahluwalia, I will be just touching upon 4 minutes more. And this is the principle of vicarious liability. Whatever is done, हे खूप छान स्टोरीज आहेत सांगण्यासारख्या आहेत. परंतु ह्या लँडमार्क जजमेंट्स आहेत त्याच्यामध्ये ही जुनी केस आहे 1998 ची आहे. त्याच्यामध्ये 4 वर्षाच्या मुलाला टायफॉइडसाठी क्लोरमफेनिकॉल दिलं जात होतं. And it was Sunday morning like this. त्यावेळी रामायण सिरियल चालू होती त्यावेळची ही गोष्ट आहे. आणि द डॉक्टर्स वर सिटिंग इन दिल्ली, दिस इज अ केस फ्रॉम दिल्ली. त्याच्यामध्ये ते रामायण महाभारत वगैरे बघत होते आणि इकडे ह्या मुलाला क्लोरोमायसिटिन चालू होतं, क्लोरमफेनिकॉल चालू होतं. द सिस्टर नर्स ऑन ड्युटी, she had to attend church and therefore she was in a hurry, gave a prescription of chloroquine instead of chloromphenical. So the dispensing chemist, Ruby Hallच्या साईडचं हॉस्पिटल आहे, स्प्रिंग मेडोज आहे, त्यांनी 5 milliliters ampule of chloroquine was given instead of chloromphenical. The nurse was in a hurry. She just broke it open. Efficiency, no? Pushed it into the tubing and the child became a brain dead instantly. He's still alive. And brain death is worse than death, I tell you. Brain death is worse than death. त्याचं कॉम्पन्सेशन त्यावेळी 17.5 लाख. तर डॉक्टर कुठे होते? करेक्ट ऑर्डर दिलेली होती, अक्षर चांगलं होतं, कुठे कन्फ्युजन नव्हतं. द ड्रग वॉज गोइंग ऑन फॉर 4 days. इट वॉज अ सिली मिस्टेक ऑफ अ nurse, but it has to be compensated by the superior. Respondent superior is the principal. त्यांना एम्प्लॉय कोणी केलं होतं? हॉस्पिटलने. So it is hospital's responsibility. Now here is one more lesson. So employ proper people and have proper checks. Also take an indemnity insurance for the hospital, even for the untrained staff. कारण ट्रेन स्टाफ मिळतच नाही भारतात. तुम्ही रुबी हॉलला जा आणखी कुठे जा, it is not 100% trained staff. You have to employ such people. त्याला 7% extra premium आहे, 7% extra premium. Pay it, but take it. The untrained people should also be covered. And ह्याच्यामध्ये काय झालं, इन्शुरन्स कंपनीने नेहमीप्रमाणे हात वर केले. प्रीमियम घेताना वा तुम्ही सगळं कव्हर करतो. When it comes to settlement of claim, they will find out बारीक loopholes. तुम्हाला सगळ्यांना माहिती आहे. आणि मग त्यांनी काढलं की अनट्रेन स्टाफ होती. But the hospital was smarter. You have to become smart. Hospital was smarter than this insurance company. They had already paid extra premium for the untrained staff. That is why it got get covered. That time it was 17.5 lakh rupees highest compensation. त्यानंतरचं कॉम्पेन्सेशन 1 कोटीचं आहे. आताचं हायेस्ट कॉम्पेन्सेशन 1,80,00,000 आहे. तेव्हा ह्या सगळ्या बऱ्याच केसेस आय कॅन गो ऑन टॉकिंग. आय थिंक एव्हरी गुड थिंग हॅज टू कम टू एन एंड. This is the latest report. I would just cover this particular case. Wrong USG report. Udayan versus Dr. Girke and Imaging Point Nagpur. I discussed this case with Dr. Milind Naik, who had come as our guest yesterday. So gross error, gross mistake, gross negligence. 4 वेळा antenatal sonography झालेली आहे. At 9 weeks, 17 weeks, 26 weeks, 34 weeks. And this child had gross limb abnormalities which were missed. Yeah, I'm just covering this particular. And the child was born by cesarean section because of obstructed labor. This was 37-year-old primary gravida, diabetic, not gestational, regular diabetic mother. And these were multiple anomalies, missed orofacial anomalies also. And the compensation given is I think 1.25 crores. Yes, 1.24 crores. Please remember, this is particularly true for sonologists, gynecologists, pediatricians. Whenever the compensation comes of a child, it is always exceeding 1.2 crores. Now, 1.2 crores. Udaharanath, retinopathy of prematurity. not diagnosed, not suspected, not referred in time, not prevented. The initial compensation in 2007 from Hyderabad was 5 lakhs. Next compensation was 1 crore 20 lakhs. And today it is never less than 1.8 crores. Because they are very much preventable and you should ought to know. And I was surprised, sir, I was surprised that 7 months back, a pediatrician calling herself as neonatologist working in a very hi-fi hospital in Pune. There was a case of ROP and they had blamed. And she did not know that it has to be referred to an ophthalmologist at the age of 7-10 days. So this lack of new knowledge, it's not new at all, cannot be accepted by law. So please remember, you have to be updated medically also. So this is horrifying because the child becomes blind, he survives, and therefore compensation go. I think even this will go to 5 crores or something like that. With this, I will end my talk. There are several, many more cases, but the take-home messages are: be careful. You take care. I don't guarantee also that there will be no case because it is up to the next party. But then you will escape. You will come out clean. That is my wish. And we don't want to frighten you at all, but forewarning is better prepared. And better prepared, you don't lose your temper, you don't get blood pressure, you don't get strokes, and you will not get heart attacks. Thank you.
Thank you, sir. I have a small question, sir. If you are mentioning about POXO app, if doctor fails to inform police, then what are the actions or what action will
Yeah.
be taken against that
Yeah,
police?
that is section
Then
18
doctor.
and 19 of POXO Act, which says that the doctor can go in imprisonment for 6 months plus 10,000 rupees fine.
Thank you, Dr. Naurangi. The beauty about his lecture is you will get information which has come in journal 2 days back. And that speaks itself about his studious nature and competency. Thank you.
थँक्यू व्हेरी मच सर. सर बोलत राहिले तर इतकं बोलत राहतील आणि सरांना एवढं त्यांचं नॉलेज आहे तर आय थिंक वी आर गिव्हिंग व्हेरी लेस टाइम टू सर, बट सॉरी फॉर दॅट सर. We will be listening him every time in our CMEs. So I request now our President Madam, Dr. Meenakshi Deshpande, to come on the dais, and I request Dr. Dilip Sarda sir to come on the dais to felicitate sir, and I request both the chairpersons to join the felicitation. माझं पहिलं नाही बदलत आहे, माझं पहिलं जे आहे स्लाइड ती आहे पुढे. Okay. सर देते सर मी सांगितलं याला आणायला. So with this very impressive talk by Dr. Jayant Naurange sir, we have another speaker, Dr. Santosh Kakade sir. Sir is a self-motivated general trauma and orthopedic surgeon with more than 25 years of practical experience in patient care and surgery. His top management, CEO and medical director positions experience cultivating successful and long-lasting interactions with medical professionals and hospital employees. He has worked in RST Regional Cancer Center, Nagpur, BGS Global Hospital, Bangalore, Ruby Hall Clinic, Pune, Aditya Birla Memorial Hospital, Chinchwad, Pune, Sahyadri Hospital, Pune, and Vivekananda Hospital, Latur. Currently, he is a functioning as non-judicial member of the State Consumer Disputes Redressal Commission, Mumbai from 2017. Sir's biodata is unlimited. Sir has got more than 30 years of experience in the fields of medicine, healthcare management, and law, armed with knowledge of the field of insurance, His PhD in law was indiscriminately subject changing trends in the law of medical negligence under Consumer Protection Act 1986. He got the opportunity in utilizing the knowledge in both the fields, law and medicine, to decide consumer cases against doctors by patients. He has got many awards and community engagements, and he has got academic credentials that I must say here. He's a MS General Surgeon, Diploma in Orthopedics, LLB General, LLB Special, LLM from Pune University, PhD in Law, Diploma in Arbitration and ADR from Symbiosis Law School, MBA Hospital Management from Alagappa University 2008, Executive MBA Finance, Pune University, and Postgraduate Diploma in Arbitration and Alternate Dispute Resolution. He's got many professional affiliations. So with this short introduction, though it's a very unlimited, lengthy and unlimited, I think this much will suffice to you, to know you that how big is a personality here. So I request Dr. Santosh Kakade sir to come on the dais to give his talk. And the talk is on new CPA salient features. Sorry.
Usually वाचलं नाही तरी चालतं. पहिली slide ठेवा. So, good morning to all of you. At the outset, let me thank the organizers, specifically the President of Indian Medical Association, Dr. Meenakshi Deshpande Madam. And of course, the team IMA. I decided to physically remain present here, though I was in Mumbai. So I traveled yesterday evening, I reached here, and today I'm here physically because I wish to meet all of you, specifically the team which is actually there. And even if the team is replaced, the next team is very much competent and performing all the activities which are beneficial to the doctors who are the members of the IMA. थोडं मराठीतही बोलतो. गुरुपौर्णिमा नुकतीच झालेली आहे, पण त्याचा परिणाम आपल्या सगळ्यांच्यावरती आहे निश्चितपणानं. आणि आपण सर्वजण म्हणतो की गुरु ब्रह्मा गुरु विष्णू गुरुदेव महेश्वरः गुरु साक्षात परब्रह्म तस्मै श्री गुरुवे नमः. तसं इथे आपल्या इथे IMA पुणे इथे खरं तर त्रिमूर्ती आहेत. नेहमी त्यांचा उल्लेख हा नेहमी होत असतो आणि त्याच्यामध्ये सगळ्यात ज्येष्ठ हे डॉक्टर जयंत नवरंगे सर आहेत. त्यांच्याबरोबरच आता इथे चेअरमन म्हणून जे बसलेले आपले डॉक्टर भेरे सर आहेत आणि डॉक्टर संजय गुप्ते. या तिघांचंच नाव मी का घेतो तर त्यांनी एकाच वेळेला 1986 मला वाटते बरोबर आहे 95 ला. सो इन्स्पायर्ड ऑफ बिझी इन द प्रॅक्टिस ॲज अ क्लिनिशियन त्यांनी LLB पूर्ण केलं आणि they three are the guiding icons in Pune, not only in Pune, to all over India. त्यामुळे त्यांना मी वंदन करून मी माझं बोलणं सुरू करतो. खरं पाहता ऑर्गनायझर्सनी खूप एक चांगली ट्रिक केलेली आहे. त्यांनी 20च मिनिटं ठेवली आहेत. टॉपिक मोठा, दिवसभर बोलता येईल, त्यांनी गेलं हे 20 मिनिटांमध्ये तुम्हाला आवरायला लागेल. नाही नाही चुके मी तुम्ही असं म्हणलं तर मग मी दिवसभर बोलेन. Way back in 2016 मध्ये हॅलो, हा ऐकू येत आहे? काय झालं, समोरून येऊन बोलायची थोडीशी जास्ती सवय झाली, त्यामुळे मला असं वाटलं की प्रत्येकाशी संवाद साधणं हे पॉसिबल आहे. 2016ला ज्या वेळेला इथे मेडिको लिगल ऍक्टिव्हिटीची मी त्याच्यामध्ये पार्टिसिपेट व्हायलो, कारण इथे ऑलरेडी आधी चालू होते सगळे. याच हॉलमध्ये आम्ही एक वेबसाईटचं इनॉग्रेशन अनावरण केलेलं होतं. त्याच्यानंतर इथे बऱ्याच कार्यक्रमांच्या मध्ये मी स्वतः सहभागी झालो आणि या सगळ्या याच्यामध्ये गायडन्स हा नेहमी नवरंगे सरांचा, बेहरे सरांचा आणि डॉक्टर संजय गुप्ते, ऑफकोर्स डॉक्टर संचेती सरांचाही त्याला खूप मोठा पाठिंबा या सगळ्या ऍक्टिव्हिटीजला होता. अचानकपणानं 2017 मध्ये मला माझी अपॉइंटमेंट स्टेट कन्झ्युमर कमिशन म्हणजे कन्झ्युमरचं हायकोर्ट म्हणता येईल, तर तिथे सदस्य म्हणजे नॉन ज्युडिशियल मेंबर या नात्याने माझी सिलेक्शन झाली. इट वॉज बेस्ड ऑन द मेरिट, कारण जनरल आणि ऑर्थोपेडिक सर्जन अशी प्रॅक्टिस 20 वर्ष करून लॉ मधल्या 5 डिग्र्या झाल्या खरं तर, म्हणजे LLB जनरली त्याच्यामध्ये काउंट करता येईल. रिसेंटली आय हॅव बीन ऍडमिटेड टू LLD ऑल्सो, महाराष्ट्र नॅशनल लॉ युनिव्हर्सिटी, तिथे मेरिट बेसिसवर ऍडमिशन, त्यामुळे तेही मी आता पुरसू करत आहे. आणि इथे गेल्यानंतर मला असं लक्षात आलं की प्रत्यक्ष नुसती LLB ची डिग्री मिळवून आपण काम करणं आणि तिथे ऍज अ सिटिंग जज याच्यामध्ये जमीन आसमानाचा फरक आहे. सुरुवातीला अर्थात ते कळणं आणि ते काय पद्धतीनं चालतं हे सगळं कळण्यामध्ये बराच वेळ गेला. बरोबर रिटायर्ड हायकोर्ट जज त्यांच्याकडनं शिकता आलं. डायरेक्ट डायसवर बसण्याची संधी मिळाल्यामुळं ऑब्झर्वेशन खूप करता आलं. बाकीचे इतर जे कोणी मेंबर्स बरोबर होते ते ज्युडिशियल आणि नॉन ज्युडिशियल असे मेंबर्स काय म्हणजे रिटायर्ड IAS ऑफिशियल सुद्धा त्याच्यामध्ये होते. तर या सगळ्यांच्याकडनं थोडं शिकता आलं. आणि नंतर मधल्या काळामध्ये कोरोना आल्यामुळं बराच हे थांबलं, पण ऍक्टिव्हिटीज जशा इथे पुण्यामध्ये आपण करतो तशा या कन्झ्युमरच्या सगळ्या सिस्टीम मध्ये काही ऍक्टिव्हिटीज मला करता आल्या. मी आता खरं तर कन्झ्युमर प्रोटेक्शन ऍक्ट या विषयावर मी अगदी कमी बोलणार आहे. लेट मी टेल यू. प्रश्न जे आहेत ते प्रश्न आपण निश्चितपणानं त्या प्रश्नांची उत्तर देऊयात. एकच सगळ्यात महत्वाचा जो प्रश्न आपल्या सर्वांना असतो त्याचं उत्तर ऑलरेडी सुप्रीम कोर्टाने दिलंय, ते फक्त मी तुम्हाला सांगतो. आणि त्याच्या आधी ही जी बॅकग्राऊंड आहे याच्यामध्ये अतिशय महत्वाचं जे काही करायला मिळालं मला या सगळ्या सिस्टीम मध्ये, ते गेल्या 6 महिन्यापूर्वी बिईंग द सिनियर मोस्ट आणि बाकी सगळे रिटायर झाल्यामुळं मला इन्चार्ज प्रेसिडेंट म्हणून जबाबदारी मिळाली. सो आय वॉज द इन्चार्ज प्रेसिडेंट, म्हणजे स्टेट कन्झ्युमर कमिशनचा मुख्य न्यायाधीश या नात्याने काही काळ म्हणजे जवळजवळ 4-1 महिने मला संधी मिळाली. आणि त्या 4 महिन्यामध्ये मी असं ठरवलं की गेले 3-4 वर्षाचा जो काही अनुभव आहे तो आपण वापरून या सिस्टीम मध्ये आपल्याला स्वतःला काय कॉन्ट्रीब्युट करता येईल. कारण खरं पाहता कन्झ्युमर्सना न्याय देणं, ग्राहकांना न्याय देणं, आता प्रत्येक जण ग्राहक आहे, प्रत्येक जण, आपण सर्वजण ग्राहक आहोत, तर ह्या कन्झ्युमर्सना न्याय देण्याचं काम होतं का बाबा खरोखरच? तर आय एम डाऊटफुल. आणि हे मी सगळ्या लेवल्सवर मांडलेलं आहे. मला जी संधी मिळाली त्या प्रत्येक ठिकाणी सगळ्या प्लॅटफॉर्मवरती मी सांगितलेलं आहे की याच्यामध्ये थोडे बदल करायला पाहिजेत आणि त्या बदलानुसार त्याचं इम्प्लिमेंटेशन व्हायला पाहिजे. माझ्या सुदैवाने 3 गोष्टी मी सांगण्यासारख्या ज्या आहेत त्या मी करू शकलो. 10 नोव्हेंबर 2021ला मला चार्ज आला आणि त्यानंतर सगळ्यात पहिली गोष्ट मी काय केली तर सर्व आमचे 46 आता कमिशन्स म्हणतात, म्हणजे कन्झ्युमर कोर्ट जे आहेत त्याला कमिशन्स म्हणतात, कन्झ्युमर कमिशन्स. कायद्यामध्ये दिलेलं आहे 10.5 कोर्ट सुरू व्हायला पाहिजे. 10.5 कोर्ट आमच्याकडे सुरू होत अशी परिस्थिती. तर पहिल्यांदा ऑर्डर काढली आणि सांगितलं की ही प्रोव्हिजन आहे आणि त्याच्यानुसार आपल्याला ही 10.5 सुरू व्हायला पाहिजे. एक मीटिंग घेतली ऑनलाईन. सुदैवाने कोरोनाच्या काळामध्ये मी व्हॉट्सअप ग्रुप केले, ऑनलाईन सगळ्यांच्या मीटिंग्स घेतल्या. नवीन कायदा आल्यानंतर त्याचे बरेच ट्रेनिंग सेशन्स फॉर आवर प्रेसिडेंट्स अँड मेंबर्स ऑफ डिस्ट्रिक्ट कमिशन, म्हणजे आमचे न्यायाधीश लोकांसाठी म्हणून खूप मोठ्या ऍक्टिव्हिटीज तिथे मी केल्या. तर या दरम्यान अशी ऑर्डर काढल्यानंतर मी स्वतः एकतर 10.5 डायसवर बसायला सुरुवात केली. तिथे मुंबईत पंचायत होती लोकांना की ऍडव्होकेट्स मंडळींना विशेषतः 10.5 येण्याची सवय नाही कोणाला. 10 ते 10.5 या वेळेमध्ये 5 जिल्ह्यांमध्ये मी फोन करायला सुरुवात केली आणि कोण आलेले आहेत तिथे, डायस 10.5 सुरू होते का, बोलायला सुरुवात केली. आणि मग व्हॉट्सअप ग्रुपवर ते पाठवायला सुरुवात केली की हे होते, हे नव्हते, हे होते, हे नव्हते. ते 10-25ला सगळ्यांपर्यंत पोहोचायचं बरोबर. त्याचा परिणाम असा झाला की एका आठवड्यात सगळीकडे एकदम जबरदस्त शिस्त लागली आता. आणि याची पावती पण मला मिळाली नंतर. 10:30 म्हणजे 10:30ला सर्व 46 ठिकाणी आणि मुंबई प्रिन्सिपल बेंच इथे कोर्ट सुरू व्हायला लागलं. अर्थात मी प्रेसिडेंट होतो तोपर्यंत ते चाललं. दुसरी गोष्ट जी मी केली ती म्हणजे मी ठरवलं की कायद्यामध्ये प्रोव्हिजन आहे की इन्स्पेक्शनसाठी म्हणून प्रेसिडेंटने व्हिजिट करायला पाहिजे सगळ्या पूर्ण कमिशनर जे काही आहेत सगळे ह्याच्यामध्ये. आपल्याकडच्या सगळ्या 46 कमिशनर्सला मी 73 दिवसामध्ये बाय रोड ट्रॅव्हल करून प्रत्येक कमिशनमध्ये जाऊन आलो. मग तिथल्या आमच्या सगळ्या जे प्रेसिडेंट आणि मेंबर्स म्हणजे न्यायाधीश लोक, त्याच्यानंतर सगळा पूर्ण स्टाफ, त्याच्यानंतर तिथे प्रॅक्टिस करणारे वकील, त्याच्यानंतर काही व्हॉलंटरी ऑर्गनायझेशन्स, अशा सगळ्यांच्या मीटिंग्स घेणं, प्रत्यक्ष फॅसिलिटी बघणं. आणि अर्थातच स्टेट गव्हर्नमेंटचा म्हणजे सांगायला हरकत नाही, हे सगळ्यांना माहितीच आहे की स्टेट गव्हर्नमेंटचा जेवढा सपोर्ट त्याला पाहिजे तेवढा सपोर्ट या सिस्टीमला नाही. आणि त्याच्यामुळं खूप त्याच्यामध्ये लॅक्युन आहे, इन्फ्रास्ट्रक्चरमध्ये आहे, माणसांच्या मध्ये आहे. तर हे सगळे व्हिजिट्स केल्यानंतर त्याचा एक रिपोर्ट तयार केला 200 पानी. आणि मग तो सेंट्रल गव्हर्नमेंट, स्टेट गव्हर्नमेंट आणि नॅशनल कमिशन या सगळ्यांना पाठवून दिला की याच्यावरती काहीतरी ऍक्शन व्हायला पाहिजे. आणि मुख्य ऍक्शन काय तर फंड्स मिळायला पाहिजेत आणि वेळेवरती अपॉइंटमेंट्स व्हायला पाहिजेत मेंबर्स आणि प्रेसिडेंटच्या. तर हे सगळं करता आलं. आणि सुदैवाने मी सर्व ठिकाणी, सर्व जिल्ह्यांच्या मध्ये, सर्व सर्किट हाऊसेसमध्ये राहिलो. त्याच्यानंतर प्रत्येक तिथल्या वकिलांच्या ग्रुपशी तर बोललो, त्यांच्या अडचणी काय आहेत आणि माझ्या अपेक्षा त्यांच्याकडनं काय आहेत की जी काही पेंडन्सी आहे ती पेंडन्सी कमी करायची असेल तर सगळ्यांनाच मिळून प्रयत्न करायला लागतील. तर असे बरेच प्रयत्न करता आले. आणि तिसरी जी गोष्ट आहे ती अशी करता आली, ज्या वेळेला मी चार्ज घेतला त्यावेळेला सर आमचे जे प्रेसिडेंट्स आणि मेंबर्स आहेत तर अशांचे 4 महिने पगारच नव्हते, 4 मंथ्स सॅलरी नाही. तर अशी परिस्थिती होती. मी एके दिवशी उठलो आणि फायनान्स मिनिस्टरला जाऊन भेटलो, अर्थमंत्र्या. आणि तो आपल्या अधिवेशनाच्या आधीचा काळ होता. आणि मी त्यांना धन्यवाद दिले. त्यांना म्हणलं तुमच्यामुळे आमच्याकडे सॅलरी रूल झाले आणि नवीन इम्प्लिमेंट झालं, चांगलं झालं. पण म्हणलं आमच्या या सगळ्या लोकांना पगारच मिळत नाही, गेले 4 महिने मिळाले नाही. तर म्हणले असं का झालं. तर मी त्यांना सांगितलं की आम्हाला सगळ्यांना तुम्ही कॉन्ट्रॅक्टमध्ये घेतलं, म्हणजे कॉन्ट्रॅक्टमध्ये घेतलं आणि त्या एम्प्लॉईच्या ह्याच्यातनं लिस्टमधनं काढून तुम्ही कॉन्ट्रॅक्टमध्ये घेतलं, त्याच्यामुळे गडबड झाली. मग ते म्हणले तुम्हाला किती पैसे पाहिजेत. म्हटलं 15.5 कोटी आम्हाला पाहिजेत आता, हॅरियर्स आणि सगळं मिळून. त्यांनी सही करून टाकले. दुसऱ्या दिवशी सकाळी 9 वाजता आम्हाला निरोप आला की 15.5 कोटी सँक्शन. आणि असं इतिहासात पहिल्यांदा घडलं की कोर्ट कचेरी न करता सगळ्यांचे हॅरियर्स आणि हे पैसे हे सगळे 31 मार्च पूर्वी दिले गेले. तर ही एक तिसरी मला अचिव्हमेंट म्हणायला लागेल, तर ती करता आली. त्यामुळे कन्झ्युमर प्रोटेक्शन ऍक्ट नवीन बदलला कायदा. सो CPA 2019 हॅज completely changed its nature. तर त्यामध्ये तरी सुद्धा जे आणखी बदल करायला पाहिजे ते बदल काय आहेत याच्याविषयी मी काही डिटेल्स तयार केले. अँड टू टेल यू फ्रँकली, 3 आठवड्यापूर्वी दिल्लीमध्ये सेंट्रल डिपार्टमेंट ऑफ कन्झ्युमर अफेअर्स जे आहे तिथले सेक्रेटरीज आणि लीगल टीमला मी 1 तासाचं प्रेझेंटेशन 3 आठवड्यापूर्वी दिलं. आणि त्याच्यामध्ये मी सांगितलं की देर आर लॉट मेनी चेंजेस विच नीड टू बी डन राईट नाव. आणि हे जर केले, सिम्प्लिफाय केलं तरच कन्झ्युमर्सना न्याय मिळेल, नाहीतर मिळणार नाही. आता मेडिकल मॅटर्स जी आहेत ती तर आता किती पेंडिंग आहेत, प्रचंड प्रमाणात पेंडिंग आहेत. एक तर बेसिकली आपल्याला सगळ्यांना माहिती आहे की प्रॅक्टिस करणारे ॲडव्होकेट्स यांना मेडिकल नॉलेज नाही, इकडे बसलेल्या लोकांनाही मेडिकल नॉलेज नाही. ते जे सांगतात त्याच्यावरती ठरतं. आणि द रिझल्ट इज ऑलवेज अनप्रिडिक्टेबल, लेट मी टेल यू. तर या सगळ्या ह्याच्यामध्ये इतके पेंडन्सी आहे. तर या पेंडन्सीमध्ये आपल्याला जर खरंच पेंडन्सी कमी करायची असेल तर मेनी चेंजेस आर नीडेड. आणि हे सगळं मी मांडलं. आणि त्या मांडण्यामध्ये माझं ते प्रेझेंटेशन, त्याच्यामध्ये मी आणखी एक फार माझ्या PhDचा जो आउटकम होता, PhD वॉज लॉ गव्हर्निंग मेडिकल निग्लिजन्स, चेंजिंग ट्रेंड्स इन द लॉ गव्हर्निंग मेडिकल निग्लिजन्स. तर त्याच्या शेवटी मी असं लिहिलं की कन्झ्युमर प्रोटेक्शन ऍक्ट 1995 मध्ये अप्लाय केला गेला, पण दॅट वॉज नॉट करेक्ट असं त्याच्यामध्ये मी लिहिलं. त्याच्यामध्ये की त्याचे जे आफ्टर इफेक्ट झाले त्याच्यामुळं मेडिकल प्रोफेशन हॅज सफर्ड, हे मी लिहिलं त्याच्यामध्ये. परवाच्या प्रेझेंटेशनमध्ये मी त्यांना सांगितलं की हा बदल करणं आवश्यक आहे की डॉक्टर्स दो इन्क्लुडेड राईट नाव इन कन्झ्युमर प्रोटेक्शन ऍक्ट. इव्हन 2019 याच्यामध्ये लिहिलेलं नाहीये प्रत्यक्षामध्ये की मेडिकल प्रोफेशन इन्क्लुडेड आहे की नाही, पण सेक्शन 2 सबसेक्शन 46 मध्ये जी डेफिनेशन दिली आहे सर्व्हिसची, त्याच्यामध्ये तो हे आहे, काय म्हणता येईल, लॅक्सिटी म्हणा किंवा की दॅट ऑल्सो इन्क्लुड्स ऑल अदर प्रोफेशन्स विच आर नॉट मेन्शन इन दॅट पर्टिक्युलर लिस्ट. मग त्याच्यामध्ये मेडिकल प्रोफेशन येतो. So recently, Supreme Court also has confirmed, not only Supreme Court, Bombay High Court also has confirmed that medical profession falls in the purview of Consumer Protection Act even 2019. तर हे आधी क्लिअर कट सूर्यप्रकाशित का स्वच्छ झालेलं आहे. तर त्यामुळे त्या प्रेझेंटेशन मध्ये मी म्हटलं की हे ऍक्च्युअली काढायला पाहिजे. मेडिकल प्रोफेशन नॉट, आय एम नॉट सेइंग बिकॉज आय एम डॉक्टर और आय एम अ सर्जन, पण त्याचे जे फ्लॉज आहेत ते फ्लॉज आपल्याला लक्षात घ्यायला पाहिजे. आणि देर मस्ट बी सम अल्टरनेटिव्ह. आता हे पीएचडीच्या माझ्या ह्याच्यामध्ये मी अल्टरनेटिव्ह सुद्धा काही विचार केलेला आहे. तर तो अल्टरनेटिव्ह त्याच्याकरता एक कमिटी कदाचित करावी आणि ते करावं प्रत्यक्ष, अशी मी सजेशन त्या परवाच्या ह्याच्यामध्ये दिलेले. सो दिस इज जस्ट अ इंट्रोडक्शन. Thank you, sir. So now coming to a very short run of the presentation. So I wanted to tell you that it was possible for me to do that for the consumer protection system. And today also I am making all possible efforts, meeting all senior most. Because of this position, I could meet several of secretaries, ministers, and those who can impactfully help this system. And I'm sure in coming few years, this will be definitely possible. So that report which I have created, that also will be available online. I will definitely pass on to you to go through that. Now, the biggest question which has been answered, and that whether the new Consumer Protection Act 2019 covers medical profession, the answer is yes. Without reading that much, I think I will just go ahead. And so major changes have taken place. 31 sections for Consumer Protection Act 1986. Now it is 107 sections. So 3 times expanded with new provisions. We are familiar with this. What is negligence as such? We are familiar with this particular slide as well. There is growth of more than 450% of medical cases filing against doctors. Last 25 years, now what has happened? Now we have learned from Naurange sir that there are various judgments which have given certain principles which are now being applied for the further cases. So the changes which have taken place is the basis of liability is Bolam principle, as sir has told, as well as the Bolitho principle. Of course, it's very that can be colorfully storified, all these case laws, but then we don't have time. So predominant principle, it has changed from Bolam to Bolitho. Meaning is that expert opinion can be challenged and the judge has every right not to accept the expert opinion if it is not fitting on the logical analysis. We are not gods, we are service providers. Patient is consumer. Medical negligence equated to deficiency in service. Expert opinion accepted only on the basis of the logical analysis. Approach to the compensation. It is said that it is increasing, but as sir has said, it is only to certain pediatric cases. Probably there is a higher amount of compensation is being awarded, or even that Kunal Sahaj judgment you might have read or heard about. So except that, there is a multiplier method which is being used, which is used in the Motor Vehicle Accident Act. And now more worrisome is this: violence against medical professionals. Now to tell you, we tried to create a system, even in Pune, under the Pune model, we tried to develop a system with the help of retired police officials. Now I could actually travel across, and at 10 districts, at least 50 to 100 police officials teams are right now also ready, and I have details of them. But then how to use that has been actually in the what we can say it's a somewhat challenging to use that because practicality of these also to be tested. But that's a good option which we tried to develop in Pune. These are certain chapters of the Act. I will just go one by one. Consumer Protection Councils have advisory role, section 3 to 9, and they are the members of the Consumer Protection Councils are appointed by state government or the central government. This is a new one, CCPA, Central Consumer Protection Authority, sections 10 to 27. The Central Consumer Protection Authority has a chief commissioner and additional commissioners. The CCPA has the authority and the power to take suo motu action on its own on various advertisements, as well as whatever, if the CCPA finds that there is a negligence or there is unfair trade practice of the service providers, CCPA can take certainly action. And under CCPA, the collectors of all the districts, they are supposed to act and work. So I actually gave two more suggestions. One is the collectors are not aware of this act and they are not taking or they're not helping the consumer. So the workshops, regular workshop for the collectors need to be organized. So this was my suggestion, and I actually volunteered that this can be done, even planned by me as well. And one more suggestion was that the expert opinion which is given by our own fraternity, comprising of civil surgeon or dean or the heads of departments, many times these expert opinions are not useful to the judicial proceeding. So this is something which is not helping the process. So I have given a suggestion that all those in not only in Maharashtra but all over India there is a need of a continuous workshop every 3 months or 6 months, that what is their role and what they should do, and it must be protocolized. So everything I have prepared and suggested, and then that has been given to them. So we hope that this will definitely help in future to medical fraternity. Then the Consumer Disputes Redressal Commissions, district, state, and the National Commission. These are the 3-level commissions. I'm sure you will definitely come to, you might be aware that this kind of a system exists, and State Commission is the High Court of a consumer system. Mediation is a new thing which is introduced. So every consumer matter should be actually referred to mediation, except medical negligence matters, where there is a death or severe disability. So this is one thing. And then settlement is tried. Product liability has been a new one which is involved. It's a liability of a product manufacturer, liability of a product service provider, liability of a product seller. It is defined. Offenses and penalties have been defined. And of course, the penalties are imprisonment for maximum up to 3 years, and the compensation to be provided based on what is the unfair trade practice. E-commerce rules newly introduced. We know that Amazon and Flipkart, these are the renowned agencies, but there are certain very many agencies, or say we can say the service providers on e-platform. So they can be punished by complaining under these rules with mainly the CCPA and even all the consumer commissions. So these are the changes that have taken place. Some of them, sir has already mentioned that 50% deposit needs to be introduced, and the interpretation of section 2 and subsection 42. Of course, the medical profession comes under the service as such. Without going into much details, I think this was the thing. The typical word is it includes but not limited to. So list is included but not limited to. This is that particular term in which the medical profession is introduced. Unfair contract as well as unfair trade practice. Now, this act has given the power and authority. Let us welcome the president of Maharashtra Medical Council, Dr. Utture. He is a surgeon himself, and Dr. Ashok Shukla. He is a medico-legal consultant. He is obstetrician. It's okay. Now I'm coming to end. So this power and authority has been given to the commissions that any contract, even if it is signed by both the parties, the terms can be labeled as not, we can say they can be unfair. So the commission or the court can decide or declare that any specific term that can be labeled as unfair and that can be strike down. So it's possible. We know about this. We also got an answer to this. So service provided to the patient comes under the new act as well. Right. So this was a question. The answer has been given by Navrange sir as well. That we need to practice in a positive manner. We don't wish to quit the medical profession. So that is the basic important thing, because there are stalwarts who are helping all of you. So this is quite important, I think. Of course, much more needs to be done. For the development of this field, much more needs to be done. And I'm sure the way in which the IMA is coming forward and the stalwarts in the IMA, they are helping to develop this field of, we can say medical law, or we can say legal medicine. Definitely it's useful. And specific mention is Dr. Utture sir. You will find him as a president of the Maharashtra Medical Council. He has done many things for the medical profession as such, and you will come to know after his speech. Right. So risk management, as sir was saying, that is quite important. I'm not going to the details of any of these things. So with this, let me stop here, because the time limited was half an hour, but I have taken 40 minutes. So, with this, let me thank the chairpersons. माझं खरं तर नाव आपलं विसरलं बरं का.
सुजित निलेगावकर.
Okay. So I thank the chairman, Dr. Behere sir, then the co-chairman, the dignitaries who are sitting in the dais, नंतर आलेले सगळे लोक जॉईन झालेले, आणि सगळे हे सगळ्यांचे चेहरे हे मी इथं रेग्युलरली कॉमन ज्या वेळेला होतो. मी 1 वर्ष एक्झिक्युटिव्ह मेंबरही होतो, पण अर्थात नावालाच होतो. So with this, let me thank all of you for patient hearing. And if any question is there, I am willing to ask. If not, I will have to just rush back to Mumbai. So I will leave this audience as soon as you are permitting me.
Thank you, sir, for coming all the way for your brilliant talk. Just a question.
सरांनी उत्तर दिलेले आहे त्याचं, मला असं वाटतं. See, the problem is, if patient is all right, without ICU, patient बरा झाला, तर काहीही प्रॉब्लेम त्याला येणार नाही. But if something happens, then you will be held responsible. That is certainly sure. No court is going to grant you that no, without ICU you have performed. So that point will be brought, definitely. The कोर्ट काय म्हणतं की हे तुम्हाला माहिती आहे की नाही सांगून काय होत नसतं, तर तुम्ही त्याची काळजी घ्यायला पाहिजे आणि कागदोपत्री दाखवायला पाहिजे, तोंडी नाही, की तुम्ही ही काळजी घेतली होती, हे तुम्हाला त्या याच्यामध्ये दाखवता आलं पाहिजे. दिस इज क्वाइट इम्पॉर्टंट. डॉक्युमेंटेशन इज फार मोर इम्पॉर्टंट.
Sir, do you think for a 10-bedded hospital ICU keeping is possible? Honestly.
See, practically it may not be possible, but if complication takes place, you समजा तुम्ही 1000 operations केली and only one complication is there, you will be wholly responsible for that one patient. So it is up to you to decide.
Then why corporation is allowing to run a hospital without ICU? That is my next question.
त्यांना विचारला का?
If corporation is giving you a hospital license and if court wants ICU to be there, then corporation should block the hospital from starting unless there is ICU.
Sir, even corporation hospital doesn't have ICU.
So you should bring this to the notice of corporation.
मी ब्लड बुक करतो ब्लड
हो.
बॅग लागली तर वापरतो नाही तर नाही
Yes.
तसं काय करता येऊ शकतं की आयसीयू बुक केलती बेड आम्ही बुक केलती आणि इव्हेंटफुल सगळं झालं आणि कॅन्सल केलं.
See, you can definitely make all possible efforts to show that, yes, we had all preparations. See, a commonest what a gynecologist faces, that patient suddenly goes into PPH and followed by sudden तुम्ही काही करू शकत नाही. So death is certain even after cesarean section or even normal delivery. Then suddenly the patient is rushed to a hospital where the patient is declared dead. The view of the court is that when you were aware that such a complication can happen, number one, why you have not informed the patient that this complication can happen and you may die, and that should be on paper. This is number one. Secondly, means informed consent. And secondly, what readiness you had that to prevent this, and secondly, if complication takes place, how you have managed. So everything should be documented. Sir will bring out the importance of documentation, I'm sure, and you all will be benefited by
Sir.
today's whole day program is very nice one. Sir.
Yeah, 1
You are
minute.
a judge. My query about it is, suppose we take in writing at the time of consent from the patient that in case of emergency, you will be shifted to XYZ hospital as he suggested, which is attached to the, I mean nearby to the hospital. You will be shifted in case of emergency in ICU if required, since there is no ICU facility in this small hospital and the consent is taken. Will it reduce the consequence if they occur later in the eyes of the judges?
The answer is unpredictable. The judge who is sitting there, what is his view? That will prevail. Obviously, if I am there, I may not accept.
Sir,
Thank you, sir. We
Yeah.
will stop the discussion because this is unending.
We'll actually last question.
How we allow?
Sir, last
Oh,
question
sir.
maybe. Kakade sir. Hello.
Ha
good
bola
morning.
madam.
My question is, see, for a maternity hospital, for example, if we are performing procedures like MTP or any minor daycare procedures, having an ICU is impossible, I mean, very unpracticable, but then the resuscitation is what is expected to be known to everyone. And when we are calling an anesthetist, we have the boils apparatus and things related to that. So do we display a board that we do have all basic resuscitation facilities? Can that be the defense for doctors? That is one. And secondly, my submission to maybe IMA, MMC president is also here, and to you also, that it's worthwhile conducting a statistical analysis of deaths in ICU. Okay, any hospital having ICU, their mortality, because all the patients ultimately die in some ICUs. So it is better that we publish such type of a thing and then say that on behalf of IMA, we can definitely submit that ICU is, I mean, no, even ICU can't save the life of a patient. So why they are making it mandatory? So is it worth publishing such papers on behalf of IMA? That is my question.
या तुमच्या दोन्ही प्रश्नांची उत्तर नवरंगे सर आणि बेरे सर डेफिनेटली देतील, माझी खात्री आहे याच्यामध्ये. एक लास्ट फक्त एक मी कोर्टाच्या बाहेर सबमिशन करतो म्हणतात, तर तसं ते सबमिशन असं आहे की मेडिकल ऑर्गनायझेशन्स मस्ट क्रिएट such a documentation that can be accepted in the court of law. So this is a very important statement. की तुम्ही you have followed the accepted standard of practice. म्हणजे काय तर ऍडव्होकेट येतात आणि ते व्हॉल्युम्स ऑफ मेडिकल लिटरेचर देतात की जे बाकी इतर कोणाला कळत नाही. I can definitely understand, but none other member or the judge can understand. So why not to create that this patient's appendicitis, this is to be the documentation should be like this and this is to be followed like this. Though the textbooks are available, I think such a kind of documentation must be done. That's what my suggestion. I have given this suggestion many times. There are more than 40 organizations, I think, specialties, subspecialties including. So every organization must prepare, create documents, and that can be definitely accepted in the court of law. That's what I feel. Right. So let me thank all of you.
Sir, last question.
मॅडम जी परमिशन असेल तर मॅडम तुम्ही सांगा.
Sir, yes, sir. Sir, it's a never ending story.
Yes.
Everyone has to learn. Just now I have told in the morning only that you have to learn and learn and learn and read books and come attend CMEs on medical legal practice. So I thank Dr. Santosh Kakade sir, and I request our President Madam, Dr. Meenakshi Deshpande, to come on the dais to felicitate sir, and with Dr. Navrange sir.
We thank from our bottom of heart Advocate Dr. Santosh Kakade for coming all over from, I think, Nagpur to deliver a lecture over here physically, and he is going back to Bombay immediately, and a very nice gesture on his part to come over here. Also, I would like to mention here over here that we had a certificate course 5 years back of medical legal certificate course, which now we use. Certificate course is the need of the day, not only for doctors now, but also for advocates and judges. I think, sir, what is your opinion, Kakade sir? Certificate course, medical legal course in for the judges and the advocates. Medical legal certificate course for the advocates, for the lawyers.
ज्यांना नॉलेज द्यायला पाहिजे त्यांना द्यावं. मेडिकल नॉलेज तुम्हाला आपल्या लोकांना लीगल नॉलेज द्यायला हरकत नाही, पण मेडिकल नॉलेज तुम्ही जर या बाजूच्या लोकांना दिला तर दॅट मे प्रूव्ह कॉन्ट्ररी. एवढं फक्त लक्षात ठेवा. आणि सोपं नाही ते, म्हणजे डॉक्टर होऊन तुम्ही लीगल हे घेऊ शकता, पण लॉयर होऊन नंतर मेडिकल शिकणं हे इट्स ऍब्सोल्युटली नॉट पॉसिबल, बिकॉज अंडरस्टँडिंग इज व्हेरी डिफिकल्ट. Thank you.
Thank you, Dr. Kakade sir. There is a bit change in the schedule. The lecture, the third lecture will be by Dr. Preeti Jayakar Madam, facing litigations, inspections and committees. I request Dr. Preeti Jayakar Madam to come on the dais, and I'll be introducing her in short. She is a general surgeon and HFN oncosurgeon with over 20 years of experience and practicing at Vileparle, Andheri and Kurla. Madam, I am from Vileparle. She is MS DNB surgery with flying colors and is a double gold medalist at the FCPS surgery exam, gaining vital cancer surgical experience at world-renowned Tata Memorial Hospital, Parel, Mumbai. Fellowship in HFN oncosurgery. Actively, she is managing general surgery, GI surgical work, including laparoscopy and cancer surgeries. In addition, she's got diploma in hospital administration and medical legal systems. She has a master degree in medical legal practice. She has got special interest in laser surgery, breast cancer, thyroid and parotid gland. She regularly conducts and moderates online medical legal seminars and has featured on the radio interview on medical issues on multiple occasions. So over to Dr. Preeti Jayakar, Madam. Sorry, Madam, there is a limited space.
I'm sorry, this is reading good afternoon because my presentation was in the afternoon. So please read it as good morning, Pune. Thank you so much, ma'am, for your kind introduction. A very good morning to all my respected colleagues who are attending this very relevant meet by IMA Pune, here who are all in person, and all of those who are zoomed in online. I think there are almost some 113, 116, what I saw last. I'm grateful to Ma'am Dr. Meenakshi Deshpande, her team, Dr. Navrange sir, and AICL for letting me be a part of this very important seminar, which is Save Your Practice, and inviting me to touch upon this very feared subject of litigation. I think a lot of our lectures are going to be intertwined. You will all agree with me, I think everyone present here and everybody listening, that our field is very unique. We are constantly learning, improving every day with every patient. And since we just celebrated Guru Purnima just a few days back, I would like to thank all my teachers. I think Utturi sir is here, all the speakers who are here, and the chairpersons for being there to teach us and guide us through our entire journey. The lineup of today's talks is very impressive, and a lot of important topics are being covered by very eminent speakers. Being a surgeon, my focus on today's topic will be from a doctor's point of view and not purely legal. And the aspect is, I think that aspect is best dealt by legal specialists. Our life is already so hectic. I think the way we function from our day to day, morning to night, getting some time out for even our own personal work, I think is pretty difficult. And today, I think medical practice is like this guy. We are just trying to strike a balance. So naturally, when we are faced with an additional headache of maybe litigations, inspections, or any committees, our usual reaction is, let's run away. No more additional headache. But unfortunately, that is not an option here. Though it is troubling, is there a reason to be concerned? Yes, unfortunately, a big yes, because this was a survey which was conducted in 2016 by National Law University, Bangalore, which said there was a 400% increase in the number of cases filed against doctors. Now, the data is very skewed. We are not really able to get a lot of data properly, but just a few cases which I could get clearly was there was a cases of almost around 329 cases recorded in Karnataka Medical Council between 2012 and 17, out of which 33 were found guilty. And we had a total of 3,200 odd cases recorded in 2018. 19 saw little less, 3,000 cases, out of which 430 reached the state court. The most important lines are here. Out of all the cases, only 15% cases approximately were found to be genuine. Now, what does this mean? That there were almost 85% of doctors who had to go through and the entire rigmarole of litigations, all the trouble that goes in, and we were found not guilty. So you're talking about 85% which were not found medical negligence. Now, all of us doctors are going to face this situation sometime or the other in our lifetime. And for obvious or perceived acts of omission or commission. So the only thing we can do is be prepared. The keyword medical negligence on Google picks up around 11,000 entries. So why are litigations on the rise? There are a few key reasons which I have picked out. Most common and the most difficult or the most unfortunate is this, where there is a complete lack of communication. Your understanding, my teaching, my explaining, there is something which is going off, which is the reason why there is a big communication error. Now, this communication error leads to a lack of trust. All of us are dealing with patients who are basically Google doctors. So they come in with the entire knowledge on Google, they come and meet you and they only want your validation, and they will decide if what you are telling the patient or explaining or giving the treatment is actually what they want. If that was less, we have a WhatsApp university. So you have forwards and forwards of people sending information, which so-called is supposed to be true. So you have people coming up with diagnosis, you have, I think the recent 2 years of COVID has given us multiple lines of treatment, and there are people following it, and there are people who are landing up with trouble because of it. So there are easy home-based ventilator managements, which have also come up on WhatsApp. Now, this unfortunately is one of a key reason why the mindset of patients is changing. It's gone to a litigation mindset because the amount of payouts or the compensation has been huge. You're talking about crores. There is no clear-cut guideline. There is no capping. So we are landing up with amounts which are different in different courts, and we are landing up at the receiving end. Now, can anybody tell me what this picture is, the last one, which is on this side? Sorry? No, the last one with the horses. Okay, now, this is a medieval picture of a sport called jousting. Now, that I find is one of the most saddest part of our profession, because this is something which can be easily prevented. Now, all of us are seeing patients as second opinions. We are seeing patients who have come in from somewhere. So just as an example, I'm a doctor. So I see a patient who's been operated by maybe a Dr. X. He comes to me, there is a wound discharge coming in, and I very casually say, oh, this doctor, okay, he has a lot of complications. I have dealt with a lot of them. So you put a seed in the patient's mind. You're taking rounds in the hospital and you've seen a patient and you just casually say, "Arey Baba, ye doctor ne ye dawai diya hai, wo barabar nahi hai." The patient hears it, the relative hears it. This can happen even when you feel that there is nobody around you and you're talking to your intern, you're talking to your resident, and there is somebody passing by, that person can hear it. So be extremely careful when you're actually passing a comment against another doctor, because that can result in a lot of issues. Now, the last, this is a very, I have to call him a two-edged sword friend, which is the media. This is a case which has just come up, I think a few months back, in new medical college come up in Lakhimpur. A lady comes in for cesarean section. There is no electricity, there is no power backup. Lady dies. Guess who's responsible? You would say administration, you would say the electricity board, but no, it's the doctor. The doctor is suspended. So you land up having a simple fact that we are soft targets. We are responsible for everything. If there are no medicines in a government hospital, we are responsible. If there is no equipment available, we are responsible. So it doesn't matter whether you're in a private setup or a government setup, doctors are soft targets. So beware. What are we up against? Why are we doing this? The consumer or a patient can file a complaint against you in all these courts. In the medical council, criminal court, civil, consumer. Now these sounds like two words, but you're looking at different levels. Consumer court, district, state, national. Civil, district, state, national. I mean, Supreme Court, the highest being the Supreme Court. Your medical council, you have a state, you have a national. So you're looking at a series where you go into one, you appeal, you go to the next. So you can imagine the amount of harassment that we are going through on our daily lives, fitting in our work, trying to manage this. Important being that he can file it in all the above simultaneously. So you can just imagine the agony that you're going through if you're looking at even one or two of these that you're going through with any patient. So this is very important, that you need to know that you can have a litigation filed against you through all this. Important points or salient points in a consumer court, I think sir is already covered. There's a deadline of 2 years. They can only give compensation. Civil court, again, only compensation. Your state medical councils can suspend, reprimand, can give you a warning or removal of your name from a register. A criminal court can give you a sentence and or compensation. So what is litigation? It is an act, process, or practice of settling a dispute in the court of law. Now, today, what we're going to tackle very shortly is how do you deal with a legal notice? Is there a procedure to be followed in the consumer court? Police, I have written the letter, but I think sir, Dr. Irande sir is also taking it up later. And what do you do when you get a criminal court summons? How a notice is basically a formal communication to a person, intimating the person that intimating the other party of your intention to undertake legal proceedings against him. A big word basically means he's warning you that I'm going to file a case in court. Now, this can happen in a civil case, it can happen in a consumer case. There's no provision of this in the criminal code. Now, it is usually written by the plaintiff's advocate, and you will get it by registered AD or by courier. So when you get a legal notice, what is the first reactions that we have seen us doctors getting? Panic. Okay, all of us start getting panicky because we feel that it can't happen to us. We are such good doctors. We are doing our best. Why will a patient actually file a complaint? I have only done good. Panic leads to other emotions. We have a feeling that there is profound sadness. So we have doctors landing up with depression, frustration. We have doctors even landing up with suicidal thoughts. They have change of work. There are doctors who have actually changed their work. See, we get hurt very easily. We may be treating life and death situations, but we get hurt very easily. So we do our best. We work unearthly hours. We handle life death situations, but the same doctors crumble when you have something because we have not learned this. It is not part of our curriculum. So we really don't know how to handle it. So maybe if you have a friend going through it or you read it in the paper, you say, oh, so sad, so I'm feeling so sorry for him. But if you are in the place, the kind of reaction you could give could be any of this. So let's decide not to become emotionally charged when you're faced with a litigation. And today, since it's a reality, we have to be prepared. So a legal notice is either served by registered post or courier. So what do? Step one, don't panic. You need to read the documents very carefully. Now, it usually, since it's written by a lawyer, no medical terminology, so we'll end up thinking it is more like Russian or Greek. Latin, I won't say, since we already know a lot of Latin in our language. But the Russian language inside seems very odd because we really don't know how it is, what it's leading to. Read it again. You will realize that you can remember the patient. So you're looking at something which could be 2 years back. So you're looking at patients every day. We have general practitioners reading more than 100 patients a day. So you may not remember what this patient is about unless you read it again. So you read it again. You ask the papers to be brought out from your medical legal department. Read the history of the patient. Read what the patient is asking for in those notes. And when you go through your records, you will remember more. Make your own notes on a separate diary so you know what exactly the patient is about. When you read the notice, also know the patient's details, who has filed it against the patient, advocate's address. This is again important because as of now, you're looking at a consumer court procedure where if a patient is in Assam, he can file a court procedure for you in Assam. So you need to know where the advocate is located because his address will be on the top part of the paper. So in that case, we have AICL teams who are placed all over the country who can help us. Now, when you do this, make sure your notes are checked by a medical legal expert. Most important. Very important. Here he's our friend. So you have to make sure that you employ a good lawyer. One with experience in medical negligence cases, not anyone. So he has to have a good experience with this. You have to formulate a draft reply or what we call a submission with him. The reply is written by the lawyer in his language. It has to be precise. You reply to every point that is mentioned in the legal notice. Deny allegations where it is indicated. No extra information. Very important. Don't give any more extra information. Stick to what is written in the case papers, nothing more. And again, I'm repeating, don't volunteer any new information. Now, I've come to this slide. Important. Can I have a show of hands as to how many of you all have indemnity more than 1 crore? Okay, more than 1 crore. Okay, now this is again important because even today, with all these judgments coming in the media, say a few years back, except for maybe organizations like this, people are not aware of the kind of judgments coming out. But the new CPA has come up with an increased level. You're looking at a district commission, which has come up with a level of 1 crore as compensation charges. So earlier, which was 20 lakhs, is now 1 crore. So it starts at 1 crore. Now you're looking at what Sir said, if you're giving 50% as a payment which has to be made, even if you're appealing, where do we have the money? So it's always safer, take an indemnity insurance of at least 1 crore and above, and make sure that you are covered. Now, this is important because in case you're served a legal notice, the first thing you do is inform your TPA. Now, this is like your Mediclaim, your healthcare Mediclaim, where you have a cashless and a reimbursement facility. So you need to check. See, most of us just sign the papers. We give the premium, we sign the papers. You're not looking at the key points or the notes or the points written in your insurance. But one thing will be you have to inform them first. It is a priority. Why? Because if in case there is a payout which has been awarded against you, they will say you didn't inform us, we are not going to pay you. So make sure they are informed first. Send them a copy of the letter that you have got. You have to just tell them that such and such a copy has reached you and that you are denying the allegations. You don't have to give them any more information. A lot of them may assign you their lawyer. It may be a part of their protocol, or you might have to make your own lawyer arrangements, but that also is a part of your agreement. Do check the credentials of the individual who has been assigned to you. If you're satisfied, retain it. If not, there might be conflicts of interest. If there is a case which has been filed against multiple doctors, and if there is a hospital involved, same lawyer may have their own pros and cons. These are the common defense tactics which have been used in most of the medical negligence cases. Most of us may have some use of this during filing. Now, in a consumer court, remember that you may not need to be present there. It's good if you can, but it's not mandatory. Now, if you have a draft reply, which you have submitted with your lawyer, and the allegations are made and you have denied it, it is better to attach statements of experts or an authority or literature and send it across. Now, most of the times this should be enough. And if in case your the literature or anything evidence that you have proved is enough, that might stop it there itself. The plaintiff may want you to re-reply or give you another reply after this. Again, it goes back and forth till finally you have an outcome. Now, this outcome can be favorable, unfavorable. If it is unfavorable, you can appeal to a higher commission within 30 days. Your highest resort is the Supreme Court. Now, the problems that can occur, now this has happened in multiple cases, is if you are a part of a team and there are a team of doctors who are involved in the litigation, if there is a hospital related error, are they going to accept it? Are they going to say yes? One member decides to blame the other. Now, this has happened on multiple occasions. And if the hospital does not cooperate, what do you do? Now, this is a case which has just happened in Mumbai a few months back. A patient herself is an anesthetist. She had undergone a cesarean section. The gynec unfortunately left a mob behind, a big hospital in Bombay. Okay, you say fine, something went wrong. Who should the patient have filed a complaint against? The gynec? Fine. The OT sister? Fine. The hospital? Fine. She filed it against the anesthetist also. Now, where is the anesthetist going to see if there's a mop left inside? But the trend is that today's complaints are sue anybody and everybody. If you have come to the ward and you have checked the patient, you're part of the list. So you have to be aware that in case you are not even primarily involved in resulting in whatever has happened to the patient, you may still be sued. So make sure your notes are proper. So what could be the solutions for this? If being together is going to help your case, go ahead with it. If it is not, then introduce your own lawyer and make sure that that lawyer also knows what is happening, so you're not going in different directions. And don't try and throw your colleague under the bus, okay? Because that can again prove detrimental. Now, this is again a new thing which we have, mediation, which is available, but this is only available when you get the legal notice. The patient might tell you that, Baba, I'm looking at this much money. You can obviously negotiate. And if you only feel that the result may not be unfavorable to you, you can use this option. I would not recommend it if you feel that you have not been negligent. Do consult your lawyer and the indemnity insurance regarding the same about the payouts. It has to be formally done. It cannot be done just verbally. And in case an ongoing civil case, we can do it. You're making sure that the judge is aware of it. There is no option in a criminal case. Now, in a criminal court, the patient cannot directly file a case in the criminal court. You're looking at a totally different procedure. So if the plaintiff has gone ahead, there is a grievous injury, there's a death, and the police are not helping, only then I think there's a provision in which they can go directly to the criminal court. And it begins with a police complaint filed by the relatives. These are again points I think Mr. Irande sir is going to be helping us later. But yes, you can be arrested only if certain provisions are in. You can get bail and an FIR only later if the thing has been proved against you. So this is a usual proper procedure, just in short, where a complaint is registered in the police station of the particular jurisdiction. The details are recorded in their register. The police asks you for evidence, you give the case papers. Written letter is a must. Please remember that. You submit the papers, the police takes the papers to an expert committee, decides if there is actually a chance of criminal negligence, and then they can file an FIR. Do not entertain oral requests. Politely listen, take his complaints, take it in writing, acknowledge the letter, read the letter properly, check the details again with a medical legal expert, and then hand it over. Make sure that you're getting a acknowledgement that you have given it. Do not volunteer information in the police station. This is very, very important, because you land up in a situation where you're a little worried because you're facing a police. All of us have been brought up with that fear of police. So if they ask you a question which is not really a part of what you're going through, don't answer it. Tell them that, okay, fine, whatever you want, give me in writing, I'll reply it back. So make sure, again, I'm telling you, make sure that before you hand your papers over to the police, that you have checked it with a medical legal expert. Double check your notes. A small word and it changes the meaning completely. Okay. Thank you. It's not coming back. Okay, so I think all of us have read that in detail. Now, these are some tips as to what to not do in court. Okay, now see, this is a situation I think we'll be most comfortable in an ICU with the patient, and we are trying to ambu the patient, we're trying to treat the patient. But in a court, we really don't know what we are really expected to do. How many of you all have had court experiences? Okay, okay. So you all know it's a completely different system. You're looking at a new environment completely. So this is what you do. Okay. You do not speak to the relatives or their lawyers. Okay, you don't try to interact with them and tell them that, okay, fine, let's try and, I did this, I did that, but still, something went off. So even if you try to be nice with them, it may not work out. So it's better not to speak to the relative or the lawyer, because he's already gone ahead. So you've already crossed that stage. Don't speak ill about the hospital colleagues. Don't volunteer any extra information at that time. Don't appear arrogant, rude. Don't answer till you're not sure what the question is. Don't tell lies. Okay, very important. Don't tell lies. And in a court or criminal court, never ignore a summons. Okay, it can lead to a warrant. You have to try to take these things seriously. There are time frames involved, even in a notice, 7 days, 15 days. Try to stick to it. If there is a problem, make sure that you have done the process again legally. You need to be present on time. A criminal court has to be taken extremely seriously. Dress formally. Your counsel can help you prepare you for the type of questions. Now, I have faced one or two, so I know how ridiculous the opposite party. They don't know what they're talking about. They don't know medicine. So they will ask you questions that they think will help them, but it may not really be true. So make sure that when they ask you questions, you understand it. So if you're not sure, ask them again and answer truthfully. Don't answer yes or no. They'll ask you, ye karna chahiye tha kya? You don't answer yes or no. It may not be a yes or no question. You say, I will explain it. It is not a clear yes or no answer. Don't get emotional. Don't get scared, and stand your ground. Can we prevent litigation? Yes, we can definitely try to prevent them. The most important thing is we have to get back to the old doctor-patient relationship. This will come only with good counseling. You have to be a good listener. You have to communicate well. A lot of the new batches of the trainees coming out, I've really found them not able to communicate. It's like, okay, gallbladder problem hai, kal nikalna padega. But what? Why? Explain, because the patient is not what he was 30 years back. He's not going to listen to you and say, fine, you aapne bola to nikal do. It doesn't work that way. Learn to talk to them, take an informed consent. Strict record keeping is the only way out. Make sure that every line you do, right from your OPD till your discharge, has to be strictly maintained. Make sure that once there is no excuse. You may see 300 patients a day. You may be operating 10 cases a day. If your records are not proper, nobody can help you. You cannot say that I was not aware of it. You have to be aware of the latest things happening in the medical legal world also. Even though the legal aspect is connected to it, it is going to affect our lives. Maintain the standard of care. Do not deviate from it. It will again backfire. Coming to the next topic, I think I'll just cover this very fast. Inspections are multiple, I think, mainly for nursing homes and hospitals. So you're looking at the inspections from the local municipal body, from the fire, from the NABH or infection control. The Bombay Nursing Home Act also has the provision for inspectors coming in. And I think the most important for all the radiological setups and GYNAC setups is the PCPNDT. You must remember that in case somebody walks in without letting you know, you can be polite, but you have to be firm. You have to figure out whether they are actually genuine. So ask for credentials always. Check it with the higher authorities if you're not sure, because I'm sure you'll have seen in the newspapers and in our journals that there are people coming in who are actually fraud. They're not people who are actually genuine, and they bamboozle us and let us go. So don't get bamboozled, don't get railroaded. Always check credentials, make sure they're authorized for that scope of inspection. Provide the necessary information as required and take acknowledgement when they leave. Beware of this category. I've written it in red because this is the people who have created a maximum problem, especially during COVID. So you have to be very careful of all these people who come in and walk into your clinic or your nursing home. Committees, I think towards the end, I really have not too much to write about this, but you do face committees once in a while, again, more in corporate setups. The important thing is take it seriously. If there is somebody who's approached you from a committee and you have to present your version of it, make sure that you're prepared. Just don't go walk in and say, okay, fine, there was no role of mine in this. Have your proof ready, talk to them with proof so that the matter ends there and there. I think I have to tell you all a big thank you for being such patient listeners. I think it was wonderful being a part here, and I must thank you all for this wonderful session that you all have organized. Thank you, sir.
Thank you for your speech, and we got a lots of thumbs up and hearts on the screen from online viewer. That itself states that this talk was very useful for our viewers.
Yes.
I would like to quote one Sanskrit subhashit. Ashwam naiva gajam naiva vyagram naiva cha naiva cha ajaputram balim dadyat daiva durbala ghataka. So it means that when you are weak, only weak people are given bali. So you mentioned earlier, even there is a lack of electricity, doctor is held responsible. In Nagar case, we have seen there are fire incidents, but doctor was held responsible.
Yes, sir.
So why we are weak? So we should come up on platforms like this, strengthen ourselves, sharpen our claws, and let's fight it together. Thank you very much.
Absolutely true, sir. Thank you.
Thank you very much, madam. You want to ask question? Yes, sir. And you always laugh.
So the list is endless. But the only
Yes.
thing is, just keep your wits about, because like I said, we are more comfortable in ICU, with 10 patients beeping, but in a court of law, we are totally flummoxed because it's too new and we don't know
Yeah.
what's ahead of us. I
Yes.
think it should be taken as a part of our education curriculum now also, but I don't know when that will come in.
Yeah, it will come. Now I request our President, Madam, Dr. Meenakshi Deshpande, to come on the dais to felicitate Madam. And I request both the chairpersons to join the felicitation.
coming from Mumbai. He's come all the way from Mumbai.
Thank you, Chairperson. Yes. I request Dr. Meenakshi Deshpande Madam to felicitate our chairperson, Dr. Subhash Bere sir and Dr. Sujit Nivilegaonkar sir.
Very much for accepting our invitation. This on the office bearers to come. With the chairperson. There is a Utture sir, Ashok Shukla sir can also come.
Yes. Yeah. Dr. Ingre sir, Dr. Shahid sir.
सब लवकर गेले.
So there is a tea break of just 5 to 10 minutes. Please go and have tea. It is served outside. Yes, thank you, Dr. Behere sir and Dr. Nilegaonkar sir. Please have tea and come within 10 minutes. So the next session will be starting. Yes.
अनिकेत
अरे पटकन वर या, त्यानंतर दुसरा फोटो पाहिजे. उशिरा येऊन जाईल, पुढे उभं राहते. आता मला सर येतात का बरोबर? अरे मॅडम काही असं
आतमध्ये चहा नाही आणायचा. सॉरी 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 सॉरी.
परफेक्ट रायटिंग आहे का परफेक्ट?
अनिकेत सर बाहेर गेलाय बहुतेक.
हे जरा काहीतरी करायला हवंय. फारच विचित्र आहे, यायला रिस्की आहे.
साहेब मागे घेऊ का सर? नाही, नाही, एकेकाचं सुंदर असतं ना ते. जरा पुढे नाही ना दाखवू.
हवा वेगळे हात वेगळे लागले. हा, ते जाऊ जाऊ.
नाही, नाही, जाऊ दे, चहा
बंद, चहा
झाला.
पहिले जा. झाडं काही आपल्याला.
आता मी तिने असं सगळं केलंय ना, त्यामुळे आपण मेडिको लिगलचा रिपोर्ट देतो ना. आपण बोलतोय असं. मला कळत नाही असं, मी आम्ही काही प्रोसेस नाही
चष्मे ह्याच्यामध्ये बघ ना. आता तुझं का? मॅडम तुमचं माझं काढ. मॅडमचं पण काढ ना. मी सुनील बोलतीये. सुनील सुनील आमच्या मॅडमचं काढ. मॅडम बोलत नाहीये. बोला ना मॅडम. नाही काश्मीरी नाही. मला असं वाटतंय की टी ब्रेक झालेला आहे, सगळेजण रिफ्रेश झालेले आहेत. सो विल बी स्टार्टिंग द अनदर सेशन. अँड ॲज आय टोल्ड यू की एकापेक्षा एक सरस. हा या या. So now it's 11:40 and we'll be having 3 sessions, half an hour each. With first, as usual, it will be starting with Dr. Shivkumar Utture sir on NMC in doctor's life. And the other lecture will be Dr. Ashok Shukla running OPD and daycare centers. And then it will be followed by Mr. Rohit Mishra, Apex Discover Insurance. And then there will be a lunch around 1:15. So please be there. I'll introduce Dr. Shivkumar Utture sir. Yes, yes. Yeah, they are all, I think, having tea. Many of the medical students have come here, and thank you, Miss Kataria madam. She has motivated all of them, and I think they are very, very lucky to attend this medical legal aspects of for learning before their MBBS. So they are really lucky. So thank you and welcome here. Dr. Shivkumar Utture sir doesn't require any introduction, and I feel very awkward to introduce sir. Sir is the president of Maharashtra Medical Council, member of National Medical Commission, member Medical Advisory Committee, past president IMA Mumbai branch, ex-executive committee Maharashtra Medical Council 2011 to 16, NWG and CWC member IMA headquarters, national coordinator of National Working Group of IMA headquarters, professor of surgery, Grand Medical College, honorary surgeon at St. George's Hospital, honorary surgeon Fortis Hospital, honorary surgeon Susrusha Hospital, and he's got many awards. Sir has told me to stop, so now I think yeah. Yes, sorry. No, I will, sir, we have to wait for a minute.
Oh, yes, I'll wait.
It's as usual, I saw you and I immediately called you. But before that, I have to call chairpersons. Chairperson. Yeah. So I'll be calling our past president, Dr. IMA Pune branch, Dr. Mohan Joshi sir. He is also past president IMA Pune Ophthalmic Society. He is a joint honorary secretary IMA Maharashtra State, and he's ophthalmologist practicing just nearby our IMA Pune, and he's a chairman of IMA Art Circle. So he's arranging every year. He's arranging tours in India and outside India. So let us see where he'll arrange this year. So he may announce now also. I can't say. And the next chairperson is Dr. Uma Wankhede. At present, she is HOD of gynecology and obstetrics at department at Government Medical College, Baramati. She is Executive Vice President, Pune Obstetric and Gynecological Society, and she is very means loving teacher, and she's a teacher by heart. So every week, at least 1 or 2 lectures she's giving, and the students are also very lucky to attend her, and as well as we also feel very lucky to attend her talks. So over to sir. Sir, sorry. I made you wait.
So, good day, I would say, because not morning, not afternoon. So, good day, everybody. And at the outset, I think I must thank the Pune branch led by Madam President, Madam Secretary also, and of course, my senior colleague, Dr. Naurange sir, Dr. Bhere sir, and all diggers who are sitting over here. And the chairpersons also, Dr. Joshi and Dr. Madam Wankhede. And basically, at the outset, let me say that Pune has always been the center of learning, but I feel another distinction should be that Pune has become the center of medical legal learning. Because the number of programs that you have arranged, I don't think anybody else has arranged. So I think I must congratulate you. Because let me tell you, being in the council, I have also come to know what is the importance of, knowing this medical legal aspects. You may be excellent surgeon, excellent physician, practicing for 40 years. And then suddenly one case comes and then you start feeling, why the hell did you take up medicine? So I think these lectures are going to help us tomorrow to exactly know what we are supposed to do. And main thing is what we are not supposed to do when we are practicing. So congratulations, I think, to the whole Pune team. For years, you all have been doing that. And it has been an advantage for me also, because though not being a lawyer, I have been called by Pune off and on. So I get to meet all my friends also over here. So now let us come to this talk which has been given to me. I think even this is the first time I'll be talking on this. It's a very, very new topic because National Medical Commission, as you know, has just recently come into play. And there are a lot of changes which are taking place in National Medical Commission. We have seen the MCI, which was there before this. They had some rules, regulations, everything which were there, but they were stagnant for years. And we used to talk about those rules, regulations. And then when National Medical Commission came in, they have taken, in these last 2 years, we in the National Medical Commission have sat together and tried to bring some new rules and regulations which you as a practicing person have to do in your day-to-day practice. And I'll just go a little bit fast as far as, and I will stick only to NMC and the practicing doctors, because it's a huge topic, undergraduate, postgraduate, medical colleges, etc., etc. It's huge, but I will stick to only as far as we practicing doctors are concerned and how we are going to be affected because of these new changes which are coming in the National Medical Commission. I will not be talking the rules, regulations which were there in the old MCI, Code of Conduct, Code of Ethics 2002, which are repeated in this NMC. I will talk only of those aspects which are new. And let me tell you, there are a lot of new aspects which are coming in. Some are good for us. Means I would say excellent, because we were suffering because they were not there in the old ethics. But some are there which I think are going to be a little problematic for us. Already in the NMC, I have personally also put my objections to all these because this is a draft. I'm going to talk about the draft. This is not the final, notification which has come. And a lot of changes are expected to be there because we have been talking to the committee also over there. So basically what you have to understand is that come 2020, the National Medical Commission 2019 Act came into play. 2020, the National Medical Commission was formed. And this body being the apex body for us medical practitioners, we should know what this body is and who are sitting in this body. Unfortunately, when I talk to my colleagues, they yet don't know what the old MCI was. Nowadays, because Maharashtra Medical Council has become a little active, people have started recognizing what is Maharashtra Medical Council. But I remember when I came into Maharashtra Medical Council, and I used to ask my colleagues, what is your MMC number? They used to quote the IMA number. So, you know, that was the state which was there. But today, definitely, so you have to understand that this is a basic body of 33 members which are there. So the chairman, 10 ex officio members, all these are government people who are sitting over there, nominees from the government, like the 4 presidents who are there of the UG, PG board, the MARB and the EMR. So these are 4 bodies under the NMC. NMC is the apex body. Under NMC, there are 4 autonomous bodies which deal with undergraduate education, postgraduate education, then EMRB, that is ethics and medical registration, and MARB, which gives accreditation to these medical colleges. So they are mainly into the teaching aspect. So they have divided these into 4 parts who work as an independent body, but under National Medical Commission. Then, of course, the DGHS is there. Then ICMR director is there. Director of All India Institute of Medical Science, he is over there. 2 persons from all these, if you see, and as of now, I think we have got which is the pointer part? चालतोय का? लाल का दिसत नाहीये. Anyway, you know, Dr. Badwe from Tata is one of the members over there who is sitting over there. Luckily, so Maharashtra has got a lot of representation as compared to the other states. And then if you see, these are the main, the 22 part-time members. See, there are full-time members and there are part-time members. All the members of the boards are full-time. By full-time, I mean, what the difference between what MCI was before? MCI, we were all honorary members who were sitting, just like how in Maharashtra Medical Council we are sitting today. But now these are employed by the National Medical Commission. They are given pay as per how a professor, associate professor will be given pay. And they are supposed to be working from 9 to 5 over there. Right? So they have to be based, even if they are from different parts of India, they have to be based in, they have to be, somehow this is not coming. Anyway, around there. They have to be based in Delhi. So they have to ship back baggage and stay in Delhi. Then of course, the 22 members are the part-time members who are over there. And of these 22 members, 3 members are from prominent, you know, personalities who are there. They can be medical or non-medical. 10 members who come from amongst the health university vice chancellors. So they are picked up from all the health universities which are there all over India. Out of that, 10 members will be there by rotation. And then 9 members are from the state medical councils from amongst the elected members. Now, what had happened when NMC was first mooted, at that time, there was a lot of opposition, especially from the medical groups, because there were no elected members. There were only nominated members originally in the 25 members, which were, you know, which was in the original draft. So the government tried to find a way out where they didn't want elected members over there. So what they said was, amongst the elected members in the state medical councils, we will take up 9 people. So they will represent the elected. So I am there on that as one of these members from the elected members. And then, of course, there is something called as the Medical Advisory Council, which is there. In the Medical Advisory Council, you have got all the members from the vice chancellors, all vice chancellors of all health universities, and all members from each state medical council. Everybody is there. Remember, only 9 of us from the state councils are there. The other state councils do not have any representative. So they come and do what is called as the Medical Advisory Council, which is, I have put it in inverted brackets because we have had 4 meetings already, which is supposed to be advising the NMC on the things that the NMC they should take up. Unfortunately, that never happens. So basically, this is the structure of the apex body which governs us as of today. And what are the main functions of this apex body? One thing is maintaining a high quality and high standards in medical education. So whole of medical education, right from undergraduate, postgraduate, super specialty, fellowships, everything comes under the National Medical Commission. If you want to be accredited and get a qualification which you can put down on your paper or your card, visiting card or anything. Then lay down policies for regulating medical institutions, medical research, medical professions. That means any medical colleges, what is the area required, what are departments required, how many teachers are required, what should be the ratio between the teacher and students, the bed and students, the bed and teachers. Everything is laid down by this council. Then, of course, assess the requirements of healthcare. Now, this is very, very important, and this we have taken up in a big way. What we found statistics was that the majority of the medical colleges were concentrated in the states below Maharashtra, a little bit Gujarat, but below Maharashtra, if you see, that means in Tamil Nadu, Maharashtra, Karnataka especially, highest number. And then Kerala also, a small state, but numbers were great. Whereas the northeastern states absolutely had a dearth of medical colleges. So the new decision which has been taken now, of course, that has still to be notified, is that no more, depending on the population, no more new medical colleges would be encouraged in these states where there is excess, unless they go to a rural area where there is no medical college. Number one. Number two, no medical college would be allowed to have more than 150 seats. So no more will be having those 200, 250 seats which were there in medical colleges. And even those medical colleges which were having more than 150 seats, they would be encouraged to have a satellite medical college, where it would be divided into 150 here and the satellite would have 100, which would be again in a place where there were no medical colleges. So this way, we thought that we could distribute these medical colleges all over India, because as you know, when there is a medical college in a particular region, definitely the health statistics in that region improves purely because of that medical college. So that is that was the idea behind it. Then ensure compliance by the state medical councils of the guidelines framed and regulations. That means, if you remember, when the MCI was there, we as the state medical councils were a statutory independent body. Unfortunately, that independence goes, because we will have to do exactly. There were many occasions where the MCI had given some diktat to the state councils, but the state councils refused to follow that diktat, because in that state they felt that they didn't require that. Now that will not be there, because there it is there in the act where it is put that we are supposed to follow. So this hierarchy has unfortunately creeped in, though it's India is a federal state, but it is there over there. Then they will act as the appellate body for anything that the state councils take a decision. If you want to appeal, you have to go to the NMC, just like how it was. But there is a difference now, and I'll come what is the difference in the further slides which are over there. Then lay down policies and codes to ensure observance of medical ethics. And this is what I'm going to talk about. The new draft which has come up in the public domain, and which expects you to do how you practice day to day in your everyday clinics. That is what they tell you. Frame guidelines for determination of fees and other changes. This is another huge step and bold step that we have taken in NMC, because under the act allowed us to frame guidelines for 50% of the seats in all the private and deemed universities. Up till now, that was not under the MCI. And what we have done after due discussion is that the fee structure would be equivalent to the fee structure of a government medical college in that area. So this allows a lot of students who do not have the money but are good in their studies, they can take up, because 50% of these will again be, kept for. So 100% of the medical seats in a government college and 50% of the seats in this private, that means 75% of the total number of seats will be for merit. So that is what the change is. Now let us see. The last we heard is they are going to challenge this. So I hope the courts agree to this, but this is a huge step that we have taken as far as the National Medical Commission is concerned. So now let me leave the rest of NMC behind, and exactly I will be talking about what is called as the EMRB, that is the Ethics and Medical Registration Board, which day to day you will be directly related to whatever rules and regulations they put up. So what is the EMRB supposed to do? EMRB is supposed to maintain a national register, just like how MCI used to maintain. So maintain, but there is a little bit difference. I will come to that, what is the difference afterwards. Then of course, regulate the professional conduct and promote medical ethics, which we already know, and ensure compliance of the code of professional and ethical conduct through the state medical councils. That means again, they will be sitting on the heads of the state councils as far as all these ethics is concerned. So that is the difference that is there. They will be continuously in contact. I still remember when I was in the council before this term for 5 years as an executive member, very, very rarely we ever spoke to MCI or we ever had a meeting with MCI. Now the government has said that there should be no differentiation. You should have regular meetings with the state medical council so that each of you know what the other is doing and they understand what they are supposed to do as far as the in the states, what they are supposed to follow as far as what the National Medical Commission has put down. Then of course, as I have already said, that who is going to be the appellate jurisdiction? It is going to be the EMRB board. So if anything goes wrong or you feel aggrieved with the decision given by the state councils, we used to go to the MCI, but now it will not go directly to NMC. It will go to the EMRB board first, which is again a independent body under the National Medical Commission. So where a state confers the power, this is a very important sentence, that's why I put it, upon the state medical council to take disciplinary actions in respect of any professional or ethical misconduct by a registered medical practitioner or professional, the state medical council shall act in accordance with the regulations made and guidelines framed under the act. That means NMC Act. So whatever is written in our state medical council acts, as I am again repeating again and again, because let me tell you, you are protected a lot in the state act. That protection has gone now as far as individual doctors are concerned. Then of course, let us come to how they will go about as far as this registration and these different ethics is concerned. A unique ID number is going to be generated. And this is going to be for you and me, everybody, not only for the new members. Till now, what you used to do, you used to apply to the state council. The state council used to give you a number. The old numbers were just numbers, which we had. The new one starts with MH for the new students, etc. Now that is going to go completely. All this data also we have given to the National Medical Commission. They will be generating a unique number for every member all over India. And that will be basically your license number, not the one given by the state councils. So you have to get ready tomorrow to change all your visiting cards, all your prescription paper, anything, wherever you have written your number, and you'll have to put that unique number that may come within the next 6 months to 1 year. Now, why this was done? There was an idea behind this. This is a good thing that is being done. Today, what happens if I'm practicing in the state of Maharashtra, I've got one number. Suppose I'm at the border. I go to Gujarat to practice or to Karnataka to practice. I'm supposed to register with that state and that gives me another number. So in a place like Delhi, where it is Delhi, then there is UP and there is Haryana, where there's all the borders and there are doctors who are practicing in all three. They had 3 council numbers, 3 differing numbers. So ultimately what used to happen is that the number of people registered under MCI was huge because there was duplication, triplication, depending on. Okay. Plus MCI, or for that matter, though in MMC we have already done that long back, we never knew how many pediatricians were there in one district, how many general surgeons were there in one district. So the government never had these statistics to encourage those faculties where there are no members to go and practice in that area. So this is the aim behind this whole thing, because when you fill up these forms, you're supposed to fill up your details of what your qualification is and also the address of where you are practicing. So the government will have all these details. This is a good thing because again, as I said, the government will be encouraging distribution of these, especially consultants, to different areas where there is no particular consultant of that faculty in that area. So this is going to happen because of this unique ID number. Only thing, this is a huge process. It is going to take a little bit of time. The other aspect which was never there in MCI, that when you got this license, what was the duration of this license? Of course, in Maharashtra, we have been following this for the last 10 years, more than 10 years, I would say 12 years. Now MCI, see, a lot of things they have taken from Maharashtra, all the documentations and everything I have given over there. And you will see that many things which we were doing in Maharashtra has now been taken up by the National Medical Commission. And when it is taken up by National Medical Commission, it is for the whole of India, not only for one state or one region. So they have also said that your licensing period would be 5 years, right? So every 5 years, you will have to renew your license. Now, our medical colleagues ask why you want to renew the license every 5 years. No other profession renews the license. Why only our profession? Remember, in Maharashtra Medical Council today, I have more than 170,000 doctors who are registered with me. Okay. But are there 170,000 practicing in Maharashtra? No. Because I have got registrations which were given way back in 1940s, 30s, which are still pending because we don't remove them. But now under the new act, all those old will be removed. So we come to know exactly how many doctors are practicing. Every 5 years, we'll come to know in that area. Resident doctors who come to say Pune, Mumbai, from say Gujarat, Karnataka, or even from North, they come over here. They have to compulsorily get registered with MMC. Now that number remains permanently with NMC. So we don't want that. So we should know exactly which area, how many people are practicing. So this will let us know after 5 years how they are going to, how the shift is going to be there in the population of the doctors from one state to the other. That will tell us that. And then, of course, practitioners are obliged to inform and update their data regularly with their qualification, contact details, and extra thing is your place of practice. So your place of practice is also going to be very important. Data which will be collected by the National Medical Commission in the future. Then additional qualification. Up till now, they never said that additional qualification was necessary. They used to just say that you can do your additional qualification. That was written in the MCA Act. Now what they are saying is that you have to get your additional qualification done, and that should be approved and notified by the NMC, that qualification. Only then. Now this is going to be a big blow, and this I have brought to the state government. Unfortunately, I don't know what they have done after that. There is a separate schedule under the Maharashtra Medical Council, which is beyond the schedule of the National Medical Commission, where we are allowing a lot of diploma holders to get additional qualification over here. All that is going to go off. So I don't know what is going to happen to that whole group of doctors in the future, but they have insisted, and whatever we do at the state level, as I've already told you, has to be in concurrence with what is there in the NMC. We cannot do something different now, like how we were doing when the MCA was in place. So we have to follow them. And since the registration has become central, whatever we do over here will be negated by the National Medical Commission, and they will be giving you the number and the qualification. So this is going to be another thing which could be a setback for some of the state medical councils, what they have been doing up till now. And the RMP will not claim to be a specialist unless NMC recognized training and qualification in that specific branch he has done. So he has to get the training also from an NMC recognized institution, and he has to get that degree, diploma, whatever it is, which is there in the schedule of NMC. Only then. So tomorrow I cannot write Dr. Utture, cardiologist, pulmonary specialist, diabetologist. No, you will not be able to write that. At the most, you can say that special interest in, but you cannot claim yourself to be an expert unless it is registered with National Medical Commission. See, what happens is, there is a good point in this, bad point in this. Suppose I have taken some extra training in diabetology. Why shouldn't I be able to practice as a diabetologist? I would say that. But the other thing is, how many of us know that our colleagues are just writing these things without being actually qualified in that region? So this is the backlash which has come back because of some of us have gone beyond what we are supposed to be doing. So this is going to come where it will be according to that. Then prefix, suffix. Now this, I don't know why they have put that. We have opposed to that because we said that DR should be only used by modern medicine doctors. They said it's going to be difficult for us to do that because on the floor of the house, in the government, they have already said DR can be used by even the Ayush people, unfortunately. So they came out with the idea, why not put it as medical doctor? Now we have opposed that because we have said that DR is something that we have popularized and made it common amongst even the public to know. Putting MED DR is that space we will be leaving for others to enjoy. And we have to then spend another few decades just to make the public aware what MDDR is. Anyway, let us see. This is in the draft. What comes over there. But every paper will also have, you have to put, as I said, now we are putting the state medical council numbers. You'll have to put your unique ID as far as the NMC is concerned. That is going to be there on all your prescriptions, certificates, and even money receipts that you are giving. It has to have your name, the degree, and your number that is going to be there. Then you will practice only in the system of medicine in which you are trained and certified. A lot of our doctors, I don't know, especially some senior doctors go into Ayurveda and then want to practice Ayurveda and all that. So you can't practice into this. Now, this also we have put forward in the NMC. If you're going to make it compulsory for us to do that, if you see the act says that once a year, all the councils are supposed to sit together to formulate a common plan. So we said that NMC at that time should insist that even those councils pass this rule so that they can also not practice in two different issues. So now let us see if we have not yet had that common meeting, but we have said that if you are going to put this up in for our members, it should be for the other members also. You cannot have only one-sided rules, regulations. And then most important aspect is, shall not associate professionally with any unqualified person to perform any treatment, procedure, or operation. This is especially for my anesthetist friends. Lot of Ayush people are practicing as surgeons, ophthalmologists, etc., and it is our modern medicine qualified anesthetists who are going and giving anesthesia over there. Tomorrow, if something happens, you will forget that you have not done any mistake, but just because you are associated in the operation and procedure with them for a treatment which is not supposed to be of modern medicine, you can be hauled up by your counsel. So please be careful. If this comes into play, you will not be able to do that. Then RMPs who wish to practice in another state. Now, this is also something new which is coming up. MCI never told you that you had to get registered with the state in which you practice. So if you shift from one state to the other state, what the MCI said, that if I am registered in Maharashtra, my number and name would automatically go to MCI. And on the basis of that, I would be able to practice anywhere in India. I don't require to practice, say, suppose I shift to Gujarat. I don't require to register in Gujarat. But you know what legal problems used to happen? What does the state act say? That I can take action against you or hear cases against you only if you are registered with me. That is the state councils. So suppose someone from Gujarat tomorrow comes over here and he's not registered with me, but he does something over here which comes to the council for hearing. Legally, I'm not supposed to be. Then who will? And what does Gujarat council say? This act was not under our borders. So our jurisdiction is only in these borders. So this was creating a lot of hassles. So now the National Medical Commission has made it compulsory that if you want to go to another state and practice, please get registered with that state also. So all this hassle, but your number will not change. So at the most, instead of just MH for Maharashtra, they will put a stroke and they will put GUJ, Gujarat. I'm not saying this is coming because we have to just still think over how to go about, that nomenclature, but your number will remain the same. Only the state will go on changing. So this is going to definitely help even the state councils tomorrow when we don't know what to do with these doctors. If there is a case filed against them. Then CPD. This is another thing that they have borrowed from the Maharashtra state. You have to feel proud that a lot of things they are borrowing from Maharashtra state. This was never there all over India. And some of our members used to complain over here, why Maharashtra, why we should do CPD, why we should do CME. See, you have to understand this, why this concept of continuing medical education came in. Medical education changes every 3 months, 6 months. All of us know that. And when there were old cases which were there in the court, I'm not talking about the council, I'm talking about the other courts, the civil courts and all. They used to ask that doctor, are you really well versed and trained in that subject in which you have treated this patient? And you had to prove it. Today, if you have done your CPD, if you have done your 30 credit hours, you can claim that this statutory aspect of the council I have done, and I am keeping in touch with what is latest in the medical education. So that is going to protect you also. That was there in some of the states, but now it is going to be across the board all over India. Not only that, the linkage of completing this 30 credit hours. See, there was in different states, if you see in Gujarat, it is 150 credit hours, 60 credit hours somewhere else. We had kept it as 30 credit hours, and that has again been taken up by the National Medical Commission. 30 credit hours in 5 years. And if you have to get your renewal done, you're required to give these details of the credit hours. So same thing that we have been following now will be followed all over India. Another good thing that has come is this point of right to remuneration of the RMP. If you see what the act and regulations say, that your patient should know how much of money he is supposed to spend when he comes to you. That is going to come, by the way. You may not, we have opposed them asking us to put in every hospital, the rate chart, like how, in a Udupi shop, those menu of dosa, masala dosa and idli and all. We have opposed that. But as a, as a go-between, we have said there will be a booklet which can be kept, which tells you all because the patient has also to be empowered to know exactly how much he's spending on his medical bill. So in advance, he should be told, because unfortunately, as I said, again, this is a backlash for some of our own members who, when the patients ask, we also know that they said, "Arey, kuch kharcha nahi hoega. Don't worry, I am there now for you." And then suddenly a huge bill is kept in the hand at the time of discharge. So as a backlash, this has come in where you're supposed to tell them in advance. See, even when we go to a lawyer, in the first meeting only, he will tell you, my charges are 50,000, 1 lakh. Unfortunately, why are we not doing that? And that will save us tomorrow. And the clause has been put over here to him. So under the law, what was the old law? Once the treatment is stopped, you cannot stop the treatment. Now, if he's not paying you, and of course it should not be an emergency, if he is not paying you, you can put it down on paper that he is not paying and rightfully transfer the patient to any government college or whatever it is. So this is another clause that has been put, and a good step that I feel as NMC has taken. Then soliciting, I'm going a little fast. I'll be telling you only the main points which are going to affect you. So soliciting of patients directly or indirectly. Now this is one thing extra they have gone beyond. And this is again timing. Arre bapre. Okay, I'll have to go for. So thank you, because I think you should know all these things, and I don't think anybody has spoken to you about all these things that is going to affect you tomorrow. Directly or indirectly, now what happens over here? If you read, even if you're part of a corporate hospital and that hospital advertises, especially putting your photograph and your name over there, you don't know that. And what are the doctors claiming? We were not aware that the hospital is doing that. Now they have said directly or indirectly. So it is your duty to see that corporate hospitals do not do that. That is there in the rule. And by the way, slowly in NMC also, we are trying to bring all these institutions and corporates also under us, so that there is a level playing field for everybody. And some of the points, if you see, everywhere it is written corporate hospitals, corporate hospitals. So if this is passed, they will also be coming under the NMC, and they will also have to follow the rules and regulations as expected of an individual RMP. Then of course, fee splitting, Be very, very careful. I purposely put this up because recently you have seen the Dolo issue, which has come in a big way. They have got the names of the doctors also who have received these gifts from that company, because that stupid company gave you these gifts. And then in the income tax return, they said this is an expenditure on promotion. And your names are over there who have received that. All those details have been sent by the IT department to the ministry. From the ministry, they have already been sent to NMC. And the next step is NMC will be sending it to the state medical council, where we will have to haul these doctors, because in black and white it is there, what they have taken. Advertisements is another thing. You are allowed to advertise. It was there in the old also, but the time factor was not there. So nobody knew you are advertised only one day or the first week when you started a new practice or change of practice or returning back to your. Now a time period has been given, 3 months you can advertise. These 7 things which were there in the old act. Now one step beyond that also we have gone, because the corporates and everybody are. Now here again, if you see the corporate hospitals and private hospitals, everything has come into play over here. What they say is that you can place announcements in the lay press, but you can only put your name of institution, type of patients you are treating, kind of training and other facilities in that institution, and of course the fees. Beyond this, you cannot claim that we are the only one, we are the best, we have done so many patients. No. And even if you see, corporate hospital is mentioned over here, so they will also. So we have indirectly tried to bring in the corporates also under the commission. So let us see how far we will be successful as far as that is concerned. Social media is another thing. A lot of complaints we used to get. Left, right, and center, people are claiming a lot of things on the social media. In detail, it is written over here what you're supposed to and what you're not supposed to do. Okay. So you can put only factual and verifiable news of yourself as far as the social media is concerned. Avoid discussing the treatment of patients on public social media and prescribing medicines to patients on the public social media. Telemedicine is something different. That is not social media, remember. Over there, it has been defined. Now, I'm not going to go into that. That's a huge chapter. That is a huge 1-hour lecture that I gave on telemedicine. That is not social media. Social media, I mean your WhatsApp and your Facebook and your, Instagrams and all these things. So do not post photographs of your patient or scan images where it is identifiable. The scan report has got the name of that patient. Remember that. So if it is identifiable, it's a no-no, even with the permission of the patient. Right? Then behavior on social media towards your colleagues also has been defined over here. So we see a lot of fights going on in social media, you versus me, and what a doctor, what he did, what all that will not be allowed as far as NMC is concerned. Should not directly or indirectly indulge in practice of pursuing likes and follows. All of us know what our colleagues are doing. I know people are paying to Practo almost 1 lakh rupees so that they can get more and more likes. They can be put in the first 5 so that whenever the patient goes online, the name comes right on top so that they get maximum. All that will not be allowed to be done. That is all gone. So also the search engine or algorithms which are there, which leads to your name being put on the top, will not be allowed. So we have taken care of all the ethical practicing doctors, what grouse they had as far as the social media problems are concerned. Then should not request or share patients' testimonials. That was another thing. That platform itself used to put a lot of testimonials on their own, that what a beautiful doctor he is. He's one of the best doctors I have come to. I have got treated, sometimes even for cancer, I have got completely treated everything. No testimonials will be allowed to be put as far as your patients are concerned. Refrain from sharing images, healed, cured patients or surgery procedures, videos. That means I do this case, I get 100% results, this, that. You cannot put, or you cannot claim that. Then allowed to share educative material for the general public, but it should be only in your faculty. Now this came up especially after COVID. In COVID, you found even the CVTS surgeons talking about COVID and treatment of COVID. It's such a sad part. So that is why this clause has come in, that your expertise is in this area. You can give public information. You can go on the TV to give public information, but it should be restricted to your area only. Then Web page also individually you're allowed to have, but the same rules regulations will be even for your web page. You have to maintain conduct, dignity and decorum has been put, and that is for the NMC, and then soliciting of patients directly or indirectly also, just like how in other advertisements, you cannot do it on the social media. So if you see, it has been put in detail what you're supposed to do, what you're not supposed to do. And let me tell you, this is there in all the Western countries also. Wherever they allow a little bit of advertising and everything, they put down all these points, what you're supposed to not do, right? Sale of drugs. This is another huge positive that has come for us. What did the old MC Act say? Under no circumstances you are supposed to do a sale of drugs. So if you see, if you have your own hospital where you give your own drugs and you give the final bill, if it's an insurance patient, you're supposed to be put the charges of every medicine, which if you read the act, you're not allowed to do, MC Act. Now what we have put is, if it is your own patient, you're not allowed to sell for others patients who come to you with their prescription. For that you have to have a pharmacy license and FDA license and everything. But in your own hospital, this is especially helpful for our colleagues who are in small towns, who have their own hospital and their own medicines they give, or even in big towns where we give the routine medicines. Now you can sell this medicine because it has been written, allowed to sell medicine to your own patients. So that saves us from this problem, especially more and more patients of Mediclaim are coming in, for whom it is compulsory that we do that. Another good aspect is that if a patient's relatives ask you the documents, you are supposed to give it within 72 hours. So if he gives it to you on a Friday evening, imagine Saturday, Sunday, if your office is closed or anything, what happens? Now we have made it 5 working days. That means it comes to almost 1 week. If 2 days holiday, if you take. So you have got 1 week to do it. Of course, in emergency or in ICU patients, you're supposed to give it on the same day. That remains. Then within 3 years, this is another thing that again we have, as far as small towns and villages are concerned, we have objected to that. Within 3 years of notifying this, you're supposed to digitize all your records. How is it possible? Say for a GP who's seeing 100, 200 patients a day in Dharavi, or for a small town where half the time the electricity is not over there, how he is going to digitize anything? So we are asking them either to extend these dates or only in those areas where it is possible. Let us see what they do as far as that is concerned. And certification is another thing that is there. Please maintain a duplicate of every certificate that you give. Either keep a copy of a photograph or whatever it is with you, or a duplicate certificate, which we never ever do. The old rule stays where it has to be numbered. All your certificates have to be numbered. So please do that. Keep this is there in this also. And another thing I forgot to tell you, this L2, L3, L1, what I have written over there, keep a note of that also. I'll come to that slide afterwards, what that means afterwards. Then informed consent. Up till now, we used to take what was known as expressed or real consent. No more it is going to be there. It is going to be compulsory informed consent, which is again a huge topic. We have full lecture that I give on informed consent, how it should be taken, what should be told, in what format it should be taken. So be careful. Henceforth, you will have to take what is known as informed consent, which is there in every Western country also. Another thing is attending to our patients. Many a times we sit drinking tea, coffee inside and the patients are waiting outside. So unfortunately, that should not be done. Patients can complain against you unless there is some reason for delay where you have informed to the patients, be on time whenever you go to your clinic. You cannot make your patients wait for 2-3 hours. Now this, why it came? Many a places they found a serious patient who comes to you and he sits in your clinic, unfortunately, because you don't take him inside, there's death of that patient in your consulting room. So to avoid that, they have put this clause. Then of course, emergency. This is another thing, good thing that we have put, which, we will be bypassing as far as the Clinical Establishment Act Central is concerned. We'll be bypassing this, that even if there is an emergency, you're compulsory to treat it, but according to the expertise and the available resources in your clinic. So that saves you. So bare first aid you can do and then shift that patient also. That saves you if it comes in the act now. Then of course, use of alcohol. There was a big halla bulla. How can they control what I eat, what I drink? But then we got the wordings changed. We got the wordings changing, and I think this is a good thing that is there. Use of alcohol or other intoxicants during duty or off duty, which can affect professional practice. So if I drink now and I go to see the patient after 1 hour, I think that is a no-no, absolutely. Because I'm still under the influence of, just like pilots are not allowed. I think even doctors, I have unfortunately seen surgeons operating after having, unfortunately, so let us not do that. I think this is the change. I think this is an acceptable change that they have done as per the old draft. You see, you are free to choose your patient. This is another thing we have again put it down. So if you feel that this patient is a problematic patient, don't consult. Tell him that it is not possible for me to see you. You're beyond my purview. You please go to, or tell him wherever he wants to go, government college, whatever. So you're free. But once you have taken up the patient, you cannot abandon him, right? That is there. Then if you attend a patient, as I said, you're fully accountable for the actions that you have done. You cannot abandon that patient, and you are entitled for the appropriate fees, which you have already told to that patient. One more good clause is unruly, abusive, violent patients or relatives. You document that and then you shift the patient. You are allowed to do that. So that gives a little bit of protection. I'm not saying full protection, but at least a little bit of protection whenever you have got this assault on doctors on your establishment. And then of course, RMP's names and registration number, I already said, is a compulsion with the registration number on all the documents that you have signed. Do not receive gifts. I'm not going to repeat that. This is there. But what they have added is you and your family members, many are doctors who have non-medical wives or children, they take it on their names. Again, this is a no-no. Not only that, remember that it is put in the act where the NMC is empowered to ask you for your last 5 years returns and check if you have taken anything from the pharmaceutical companies. So there, IT is going to catch you, because as you know, according to the new IT Act, you're supposed to pay the tax also on whatever you get from, the companies. And here the council is also has the right, which they never had a right of asking you your 5 years. Now, good, bad, I will not comment on that, but I'm telling you what is going to be the fact in future. So another good aspect that has been put, that we have put a moratorium on the number of years that the patient can put a complaint in the council, which was not there. 4 years, 5 years, 10 years, they could complain. And we had to take up the complaint. We have put it down as 2 years. So beyond 2 years, unless the council allows them, like put in any court, no allowing them to do that. Then another thing which we have objected to is if the patient cannot complain, where the patient is not in the state or he is dead, they have allowed a friend to also complain against you. Now the friend can be an NGO, friend can be a Karyakarta, local, this. So we have objected to that, and most probably the last I had discussion with the members, we are going to remove that, but a relative and a family member is allowed to do that. Then if you do not attend, now what has happened is it is not there in the State Act or the National Act also. Suppose a case is filed against you and we have called you for a hearing. There was nowhere written that how many hearings I'm supposed to take. So it was getting postponed, and for years those cases used to be lying over there. Now it has been put down in writing that 2 consecutive hearings or 2 out of 3 hearings, if you are not present, ex parte decision can be given by the council. So this has been put in black and white so that tomorrow you cannot go against the council to the higher courts. Shall not be allowed to bring in any lawyer. That is another thing that has come in, and this is a big blow to the lawyers. No lawyers will be allowed in the council to represent you. In Maharashtra, we were doing it, but there are some states, they were not allowing lawyers to come in. So I think, I don't know, but they have said that lawyers would not be allowed because they have found that when lawyers come into play, invariably for years that case goes on. So no lawyers will be allowed anywhere in India. I'm not talking only on Maharashtra or Delhi. Anywhere in India, they will not be allowed to come. Another thing, new documents. Every time we used to have the next hearing, there used to be another set of documents brought by the complainant. So we have said that once when you are complaining, all the documents should be. So what they used to do, they used to hide those documents. We used to come to know because they're lying with them and then produce it. So again, the cases used to get postponed. So once you give those documents, you will not be able to put in new documents over there. This is especially helpful for our doctors, because the first time when he complains and gives those documents, we are supposed to give you all the documents to get your say on that. So it is going to be an advantage. You will know all the, all the documents which are there for you or against you in whatever he has submitted. And another aspect again, which we have opposed, it is written over there that the complaint cannot be withdrawn after it is admitted by the SMC or IMA. I think this in any civil court, if the complainant withdraws, the case closes. And that's what argument I also had when they put this up first. I said, you are also civil court. Your powers are that of a civil court. You are not a criminal court. Criminal court I can understand, because criminal court, it is a state which has gone against you, not even the complainant. So there they cannot take it back. But I think this will also be taken back. Then there was only up till now what was written, that in a particular case, either you can dismiss it or you can give the punishment ranging from warning to permanent removal. Now they have documented 10 different, this if you see over here, right from dismiss, reprimand or warn, counseling, alternate penalty given, restraint, RMP from performing. Now this is what Maharashtra used to do, especially in PCP NDT cases. In PCP NDT cases, because these cases used to take 2 years, 4 years, 5 years, they said you're supposed to, as soon as a case is filed against you, you are supposed to suspend them. Then that case used to take at least 5 years in the court. What should the doctor do? How should he earn the money? So what we had started in Maharashtra is, we used to restrict that radiologist or that gynecologist from doing only ultrasonography. But they used to be allowed to do the other practice so that they can continue practicing and earning money for their family. They have also accepted this time also. That you can, the RMP performing that clinical procedure can be stopped by the council. But the other clinical procedures, so gynecologists can go on doing the obstetrics, gynecology and everything. Radiologists can do X-ray, CT and everything. So that's what we're doing. One bad aspect that has come in is that you can award monetary penalty to the aggrieved party. Now, how many forum our doctors are going to go on paying? CPA we pay, civil courts we pay, criminal though we are jailed, and they can tell us to pay also. Now it has been added to the council, which was never ever there. Again, we have opposed it. I hope all of you all have read this and opposed it. We had asked from IMA, to oppose all these things. And if you have opposed it, it's very good, because that is going to be taken cognizance of before it comes finally to the main National Medical Commission. So I don't think that the council should be given the powers to give monetary penalty. Then if you have not renewed your license, you will be, or you are practicing without taking a license, someone comes from the other state, the council is allowed to charge you 10 times the fees. So now again, this is to deter you from not registering in that particular state. If you register, see, if you go as per the law, nothing is wrong as far as this is concerned. And then of course, up to, we can also ask them to take specific training in specific programs, if that is also kept. So that also gives extra this to leeway to the council. And then of course, permanent removal, which is what was there in the old one also. So if another good aspect, there are two parties, complainant and the doctor. According to this new act, if the complainant is aggrieved, he does not have the avenue open to go to the National Medical Commission. It is only the aggrieved doctor who's allowed to go in appeal to the National Medical Commission. If the complainant wants to go, he has to go to the High Court directly. It is there in the act. So that is another new thing that is this. But only thing is that whatever decision given by the EMRB board or by the National Medical Commission, it is binding on the state medical councils. And if you go to the EMRB and again you are aggrieved, you are again allowed to go to National Medical Commission. So a doctor has got 1, 2, 3 and then High Court. Whereas a complainant has to directly go from State Medical Council to the High Court directly. He cannot go through all this process. And then there are 60 days which has been given. So just like how we were doing in Maharashtra, if we if we were punishing anybody, we used to tell them up to 60 days, your punishment will not start, because that is the period we were giving them to go to the MCI to go for redressal. So code of ethics has been put down, whatever I have said up till now. This has also been put down in short. That patient's rights are there. Opinion should be honest and transparent. Confidentiality, privacy. Keep up to date with advancements in medical practice. So your CMEs are also very important. So all these things, whatever I have spoken up till now, has all been put down in one column as far as code of ethics, instead of having a huge code of ethics. This is also there written in that document. Then provide treatments that are not medically indicated. You should not provide. Now this came in because of, in some areas, if you know, hysterectomies were done for other than medical reasons. Those used to work in the farms and all that. Now that is, I don't know why our people also do all these things. So this is a backlash which has come. If there is no medical indication for that particular treatment, you will be hauled up, right? Then professional obligation owed to the patient and society, etc. So all these things are there. No endorsement, no promotion of any drugs. Please do not do that. However close you are with that pharmacy company or whatever it is. And professional boundaries, as it was there in the old, between the patient and the doctor. So this has been again put up all in detail. This is another huge hue and cry which had happened when the Charak Shapath came in. And people did not understand that Charak Shapath was only for those students who were coming into medicine. We tried to tell everybody. Even today, and this is now in the new document also, we are still sticking to the declaration of 2017, Declaration of Geneva. And this is the same document you were signing up till now. And the same, nobody takes even, forget Charak, we don't even take a Hippocratic oath today. Nobody takes Hippocratic oath. We go standard as per what the world is following. That is the Geneva Convention, what we are supposed to do, and we are going to do that. So there is no Charak Shapath after you have passed your MBBS to get your license or your degree is concerned. Now L1, L2, L3, I was telling you. Now, just like how in the courts, because what they found, or we found, that different counsels for the same type of mistakes that the doctor has given, they used to give different punishments depending on the mood of the doctors who are sitting over there giving the punishment. And of course, there used to be a lot of rivalry also, which they used to, for a simple mistake done by the doctor, they used to suspend his license. Just like in the courts. Why they file an FIR under which sections? Because under that section, I am allowed to give only 2 months punishment, 3 months punishment, 6 years punishment, 7 years. I cannot go beyond that. The court cannot go. Even if you're found guilty, you're supposed to stick that. Same principle we have put down over here. We have laid down for the type, you have seen L1, L2, which is there. You can go on the website and check that. For that type of mistake, if you have done, you will be only given this punishment. So what is that? Exoneration, where we don't find anything wrong. If it is of level 1, then we have to only give you advisory and instructions or a warning. Nothing beyond that we cannot punish you. If it is level 2, which has been defined what type of infraction you have done, we have defined the levels also. You can give given 1 month if it is level 2. Level 3, a maximum you can do is up to 3 months, not beyond that. And there is something called holding suspension, again, which Maharashtra Medical Council used to do when we found that that particular doctor has done something which is very gross. And even in the council, if the hearing was there, it used to take sometimes 6 months, 1 year. We did not want him to practice because it would be detrimental to the other patients. We used to do what is called as holding suspension, which there are legal experts here, they will know. Even the courts give that holding suspension. Even in the Maharashtra state government, holding suspension is there. That means you're suspended till a decision is taken. This has also been accepted by the National Medical Commission, and I'll not go into detail, but this definitely helps us to restrict that particular. In the rarest of rare cases, I think in my 10 years experience in MMC, we have given holding suspension to only 2 people, not beyond that. When we have had almost about 1,500 complaints. Then level 4 also from 3 months to 3 years we can give, and level 5 where it is debar you permanently. So the type of mistakes or negligence or misconduct you have done, there will be a fixed duration only that every council can give. The council does not have a right to go beyond what is laid down over there. Then of course, certificate is another thing, because lot of complaints now we are getting in MMC because of certificates which are given by our doctors, which are not as per the norms which have been put down even in the old MCI and now even in the new MCI. So they, in that annexure, they have given you the type of certificate you are supposed to give, where, you know, all these things have to be there, where the identification of the patient has to be there, either the thumb impression or Aadhaar card or whatever card, because you don't know, the patient has come to you and he says that my name is Mr. Joshi, he may be Mr. Trivedi. You don't know because you cannot identify. So you have to, on that certificate, that identification has to be there. So this is just, I put it down. A lot of such certifications, a lot of such requirements are going to be put as annexure. And if you follow this, no court of law can haul you up. So this is for your protection. It's not difficult to just get a printout of this and just fill this up. It is nothing great. So please follow that, because then even if you have made some mistake, if you have followed this, the court is not going to haul you up, right? So ignorance of law does not absolve one from judicial scrutiny. Remember that. A lot of my colleagues say that I did not know, I'm not supposed to do this, but you're supposed to know it. So please go on both the Maharashtra Medical Council and the National Medical Commission and find out what you're allowed to do, what you're not allowed to do, and save yourself, because we do not like our members to come to the council whenever there is any case filed against you. I'm sorry for overstepping and this, but then I get carried away, because I know what our doctors go through when they have to face, even I think in the morning, madam said that when you have to face the courts, you lose 10 years of your peaceful life. So don't do that. Thank you very much.
You have given us such a lucid exposure to the MNC.
It's also not working.
And we agree that there are many good points and there are so many gray areas which needs to be tackled. And it shows your depth of knowledge of the topic. You really provided a very good insight. Thank you very much, sir. And
Yes, sir. Sir, each and every sentence and each and every word was very important to save your practice. Sir, thank you, sir. I request our President, Madam, Dr. Meenakshi Deshpande, to come on the dais. Our Executive Trustee, Dr. Sanjay Patil, sir, to come on the dais, and Dr. Jayant Navrange, sir.
Top par excellence, and they are having a recording of it. So
you sent it to me also. I sent it to them.
Thank you very much.
Many people are watching from online also. Thank you, sir. Now the next lecture is on running OPDs and daycare centers by Dr. Ashok Shukla, sir. So may I request Dr. Ashok Shukla, sir, to come on the dais? Yes, sir. Sir is always there. And sir, yeah, he is saving time. He is a MBBS, DNB, DGO, DFP, FCPS, LLB, and LLM. He is a gynecologist and medical legal expert. He's an advisor for medical legal cell, IMA Maharashtra State for 21 to 23, and is a president-elect Association of Medical Consultants, Mumbai 2021-22. And he's received many awards. And two are one secretary and one president for IMA Maharashtra.
Thank you. Thank you. As we are running short of time, I thought we will have more discussion. And I have given 10 minutes to Dr. Uttare sir, so I have to compensate. So I would also like to thank the chairperson who allowed me to give. So OPD practice, now it appears to be a very simple topic, मेडिको लिगल प्रॉब्लेम आम्ही 20 वर्षापासून प्रॅक्टिस करतोय, 40 वर्षापासून प्रॅक्टिस करतोय, आम्हाला काही त्रास होत नाही, कशासाठी आपण मेडिको लिगल बद्दल विचार करायचा. But we have to understand that a lot of consultants have also now started doing OPD practice. Why? I am a 60-year-old, 63-year-old. My hospital is going for redevelopment. I have no guts now to start a new hospital, but I want to continue practicing. So what I have done is I have started my own OPD. I am a gynecologist. I practice their gynac. I admit my patients in another corporate hospitals, but I am doing my OPD practice. So now consultants have also started doing OPD practice. So already we are under too much stress, constant under stress. Morning से अपन सुनी रहे वो court अभी उत्तरे सर ने तो he gave a list of punishments L1, L2, L3, L4 where your final punishment would be you are out of the system also. So practicing with so much stress, there was a survey, it showed that 30% of Indian doctors are suffering from depression and 80% face risk of burnout. Now after medical legal conference, lot of time people feel बापरे प्रॅक्टिस कसं करायचं, इतकं सगळं ऐकल्यानंतर आता भीती वाटते की करू की नाही करू आणि पेशंट कसं बघायचं. आणि दर पेशंटला बघताना वी स्टार्ट राईक अ इन्व्हेस्टिगेटिंग ऑफिसर. हा पेशंट बरोबर आहे का, आपल्याला केस टाकणार काय, ह्याची फीस घ्यायची, हा रिसिट मागतोय, द्यायचं की नाही, वाय रिसिट इज आस्किंग, ही इज ऑल्सो आस्किंग माय लायसन्स नंबर. सिस्टर सांगते की ते बाहेर तुमचं रजिस्ट्रेशन नंबरचा ना फोटो काढत होता रिलेटिव्ह. आपण इतकं कॉन्शियस असतो सीसीटीव्ही मध्ये, आपण पेशंट पेक्षा जास्त आपण बाहेर वस्तू असतो. बट आय विल ऑलवेज टेल कोर्ट्स आर व्हेरी गुड. सी इफ यू कम and practice ethically with clean hands, court will always support. See, in judiciary, you will see every case is different. Every case is different. It is taken in different form. Same case, the thing view might be different in different scenarios. So don't get worried. We should practice. Prevention is better than cure, always. So today I'll just brief up. No, I'll be slightly fast, but these are the issues which I'm going to discuss. Medical records, death certificates, already Dr. Utture sir has mentioned, home visits and OPD procedures. These are something new which I would like to brush. Medical records, most important, good defense. If there is a record, no defense, because a lot of time you do a lot of things. नाही मी हे advice केलेलं, मी हे सगळं सांगितलेलं, but judge सांगतो तुमच्या पेपरवर तुम्ही काहीच नाही लिहिलं. So तुम्ही सगळं manipulate कर. You are just manipulating. This is just retrospectively you are saying I have advised everything, but in real sense you have not done, because the judge feels if you have not written your paper properly, you are not a good person. How good you are going to take care of the patient? That is the way they see. What does medical record in OPD basis? We normally do a lot of shortcuts and short writings. We have to see that MCA has given a proper prescription format, your OPD register, your referral notes, your pathological reports noting, because if you have seen that hemoglobin is 7, have you noted on your paper anemia, severe anemia, you have advised if the patient is not taking medicines properly, have you mentioned on the paper that patient was advised to take medicine but patient didn't took, now patient has been advised to again either to get admitted. These all findings are going to protect yourself in future. Investigations, negative consent, refusal for treatment. Lot of time you say बाबा तुम्हाला टायफॉइड सिव्हिअर फॉर्म मध्ये ऍडमिट व्हावं लागणार, मी इंजेक्शन सांगतो, हे मेडिसिन्स घेतो, पेशंट सांगतो ना डॉक्टर मी ऍडमिट नाही होणार, तुम्ही द्या ना, तुम्ही तर तुमचा औषध मला लागू पडतो. And then we give, but then something happens wrong and he deteriorates, the same relative backfires. So you have to also, if you have advised something, you have to write on paper, patient doesn't go, refusal, transfer note, OPD record keeping, your detail, history taking. Differential diagnosis, as in OPD practice, whenever you see and if you are a double mind, you might be suspecting 2 or 3 things. Write your differential diagnosis, your treatment formats, what are the options available, because indirectly the court feels you have given that much time to the patient, advise and explain to the patient, and then the patient has opted, I'll go ahead with this form of medicine or this form of treatment. The OPD paper, when I used to go to my family physician, he used to have a small diary. I am a Shukla, तो वो शुक्ला का फैमिली, तो वो डायरी निकलता था कंपाउंडर, उसके ऊपर वो उधर ही रहता था, और every code word the compounder used to understand what medicine has to be given. But we have to understand codes matters can come within 2 years now, because NMC will be having a limitation of 2 years, civil matter 3 years. Sometime the judges condone. So if at least till 3 years, whatever your papers, you should be able to read your own handwriting and paper, because a lot of time when you go to the court and then the judge says what treatment you have given, and if you're not able to tell exactly what was your diagnosis, what was your findings, the judge again feels you are now manipulating and not given much time. Digitalization, as Dr. Uttre sir has already told, very difficult at a family physician level, but not impossible. But wherever there are restriction of resources, acceptable. But I think so it's going to be a very, very good and easy life once you start learning digitalization. See, we are using cell phones, but we are not able to use all the apps on the cell phones, but our kids are able to. Why? Because their exposure is from young time. We have not been exposed, but once you start using, you will be able to. And then things would be very simple. Your appointment bookings becomes very important, because whatever receptionist give you appointment, you can see on your mobile phone. Aap kiti appointment hai, and you can see. And you can say, "Ata varche 10 sang parche mi bagu nahi shakat." She knows, she has a phone number. You can tell, "This is my important patient." This is, you have an option. And then you can get the information very fast on just a click. Digitalization, see, it will add on the cost that we all accept, which is going to go to the consumer, but there's no option. So OPD and daycare indoor papers. Now, because a lot of time people admit for a short, 4 tas daycare center la. Sir, there your record keeping should be exactly what time the patient came, what medications you have given, why you have given, date, time. If some visiting doctor has come, now somebody will see OPD mein visiting doctor, mera aage ka slides mein malum padega. Again, your all detailed procedure, whatever you have done to the patient, when those patient has been there for 4 hours, you have to see that all the papers has the marking, so that tomorrow if something happens, you are able to defend. Very important, because a lot of time we are very fast in our writing, and handwritings are still our problem. And whenever patient or doctors have to recollect and write exactly what they have written, it becomes very difficult, because they are not able to tell exactly what their intention was. Referral note. A lot of time we see in OPD patients and we refer those patients. Now your referral note should be very, very important. What was the finding? Clinical finding when you have referred the patient, whether it was an elective, an emergency, what way you had able to, have you, if you was an emergency, had you called the hospital where the patient is supposed to go, because the patient might be sitting in the waiting area because that consultant didn't knew that you are sending an emergency. All these will help in your private practice, because if there is any complication, the judiciary, you can convince her, I tried to took all my best of my care. Now there was a matter where a family physician referred a jaundice patient to a hospital saying that your jaundice is very high, but the patient didn't go. Patient went to a jadu tona, whatever. After 3 days, patient deteriorated. Then went to the same hospital where the doctor referred, got admitted, then patient died. Now the relative came and started arguing and fighting with the doctor that तुम्ही उशिरा पाठवलं, तुम्ही आम्हाला सांगितलं नाही, आम्ही तर लेमॅन आहे, तुम्हाला सांगायला पाहिजे की एकदम सिरियस कंडिशन आहे. आता एकदम सिरियस आणि कंडिशन आहे, रेफरल नोट लिहिलं म्हणजे गरजेचं आहे. But that referral note protected the doctor, because the referral note copy, as Dr. Uttresan mentioned, all has to be in replica. He showed the police officer, see, I have referred 3 days back. कोणत्या तारखेला गेले? 3 दिवसानंतर. माझी चूक नाही. I have referred. So, and I had informed also that hospital, कि such and such patient is coming, kindly take care. He didn't went. I am not this. And then the whole onus goes on the patient. But paperwork helps. A truck driver came with chest pain to a physician, 10 consultation, ECG changes, referred to a cardiologist, but not documented. ECG changes, he gave treatment, and verbally तुम्हाला ECG में थोड़ा सा मला बदल घडतंय दिसतंय, तुम्ही cardiologist दाखवा, but not mentioned. Patient died. Postmortem, atherosclerosis, myocardial infarction. Wife filed a complaint against the doctor, and ultimately doctor realized his mistake and he has to do out of court settlement because patient died. ECG was showing changes. And then later he was trying to say, I had referred to cardiologist, but paper. That's the reason your paper mainly speaks for yourself. Reference to a quack. A family physician referred to a doctor who's a quack. The patient landed with a complication. The judiciary said that you have breached the trust. When a patient comes to a family physician, when a family physician is guiding, there is a trust of that patient on that family physician. And that patient felt that wherever you are sending is a qualified doctor. So the patient is eligible to file a complaint against you that you have referred to me a quack. You have referred to a doctor who's not himself a doctor. Certificates, huge list, separate topic, but very important in the OPD level, because a lot of time we do some mistakes. Under treatment certificate now, because they have already, Uttre sir has said in NMC, they have given a format also now. So your life has become easier. But under treatment certificate, unfit certificate, light work certificate. Lot of time people, isko na halka kaam bola hai. And I had a matter when a family physician received a notice where he is a driver who drives. And now he has a light work. So owner has asked, you tell me what work I should give. He's a driver. Either he'll be at home or he'll be a job. You can't balance the thing that iska pagar bhi chalu rahe to light worker. So it is very important how long, why, because now every corporate and every department has a health department or their HR. They have a doctor on panel. They will ask you why you have issued the certificate and you have to justify. And if you are not able to justify, they might complain to the council saying that you are doing an unethical practice. You have taken money because they will be having a receipt. And a lot of time they say the charges of issuing a certificate under certificate should be very low or reasonable. So if your charges are very high, then again it becomes school fitness certificate. Lot of time family physicians get patients. Sir, ये 10 साल का बच्चा है, 8 साल का बच्चा अभी स्कूल जाने वाला है, तो एक बार आप चेकअप कर लो ना. Why these schools have started? Because one child in between had died in a school activity during sports. Now the school authorities were blamed. So what school authorities started doing is, why we should take the responsibility. We'll take a fitness certificate. Let the family physician or some doctor certify he doesn't has any problem, and if there is any restriction, it should be mentioned. So ultimately onus is on to be there. So don't just blindly sign. Check at least basic something you have. If it's your old, if it's a patient or the child you have never seen, I will say don't do. Ask them who's your pediatrician, who's your main doctor, go to that doctor. Why he has come to you, you have never seen in the past. Mentally sound certificate, very, very important. A lot of time before writing a will, they'll come to the family physician because their lawyer will advise. And they will say, doctor, oh, मेरे पिताजी अभी उम्र हो गया है. Son will come, मेरे पिताजी को उम्र हो गया है, तो एक सर्टिफिकेट चाहिए. वो आपके पास ही तो आते हैं, वो हम लोग तो आपका जूना पेशेंट है. And then you give a mentally fit certificate. And then once he dies, the will get challenged and the doctor has to go, because the opposite lawyer and party will say, oh, उनको diabetes था, वो थोड़ा सा irregular था, mind में भूल जाते थे. And then the court will ask the family physician in one visit, how did you came to a judgment that he is mentally fit? And why you give? So be very careful of issuing certificate, do proper examination, do testings. These are all registers which I'm not going to mention. Already the documentation sir has covered for how long, how to maintain home visits. Can I refuse? Lot of time patient says, a doctor says, कि sir, ये patient पैसा देता नहीं है, घर पे बुलाता है. मैं ना बोल सकता है क्या? Legally, because patient मस्तीखोर है, वो relative को लेकर आएगा, NGO को लेकर आएगा, political party को लेकर आएगा. तुम्ही कसं नाही म्हणू शकतात? And these issues are mainly seen in smaller places where the politicians are very strong, not in bigger places, because there the doctors are also less, one or two specialists only, and they get a lot of pressure from the local. So, and how much should I charge? Is home visit good for patient? See, we have to also convince the patient that home visit is not very good for patient, because you are seeing the patient in a restrictive environment. You are not able to carry the whole OPD system there. You are only going to give there a particular care, what problem the patient is having, where he needs emergency, like changing the dressing in an old person, giving some injection because it has been advised by the consultant, all this. But you have to be very careful when you are doing this. So I'll just mention about one of the court cases, Lakshman B. Joshi versus Trimbak Godbole, very old. Now here the doctor-patient relationship has been told is accepted once you treat the patient. This means a doctor-patient relationship is established. And that is only for that disease, as sir told. It is only for that disease. It is not established in certain situation. The patient comes you in an emergency. Patient comes in emergency, you have referred, the patient goes, again comes for some other issue, you can say, I don't want to treat, you can go. It comes for an insurance purpose. He has been referred from LIC or somewhere for insurance purpose. It is only for till that extent. Tomorrow patient can say, मेरे को आपको ही दिखाना है, you have a right to refuse. It is not the continuation of the same treatment. Examination of medical legal cases where the police gets you. Examination for assessment of injuries, sexual offense, disability. Here again, doctor-patient relationship is not there. So relationship is usually for the present illness only. It does not extend to unrelated different complaint or illnesses. So can I refuse home visit? Here, the privilege of the consultant as per his qualifications experience. According to law, doctors should not exceed the services. You can display outside. I don't go for home visit because of my whatever reason is. I don't see a pediatrician or a family physician here. I don't do vaccination at my place. I don't do. He has already declared. You can't say I do, but few patients you will do and few patients you will start refusing. They will say, "नहीं तुम्ही करता त्यांना दिलं माझ्या relative." But you can display. There is a disclaimer from beginning, so patient will not come and argue. Patient is seeing you, but in emergency, dire emergency, the gray zone is कि as managing, because lot of patients says कि वो घर पे बुलाया, इधर भी एक patient है तो किसको देखने का, इसको छोड़ के जाने का क्या? So that you have to see that your prudent knowledge that time कि dire emergency है, real में है. you can go and help in an emergency. As a ethics, we are always supposed to save human life. We are the only profession where we can save human life, no other profession. Cause of death, again, a common certificate which all family physicians issue in their family practice. Be very careful. Give only if you know the cause of death, and charge reasonably. You can refuse if you don't know the charge or don't know the cause of death. Whenever you are doing locum, that time you be more careful, because learn what happens. The primary family physician was seeing. Now the patient was giving the treatment. Now he's gone for a leave for 5 days. Now I am doing the locum, and suddenly the relative comes and says कि वो expire हो गए. आप जिसके जगह पे वो तो पिछले 3 महीने से हम उनको ही दिखा रहे थे. So if you are very much convinced, then only do. Otherwise, it's a very tricky situation. You might be in a problem. Identification of patient, already sir has told, because wo aake bolega my name is Joshi and you accept it. So you have to see that identification. That's the reason the older always used to have 2 marks. Either 2 marks. नहीं जोशी सर बोले सब मेरे नाम ले रहे. तो 2 marks. So thumb impression, Aadhaar card or 2 body marks is a very easy to. Now a very important slide where I would like to spend some time. Now, OPD procedures and daycare. Now, what has happened is that competitions come between family physicians. They all want to give. Consultants also have a competition. So, I have issues where orthopedic surgeon has gone to a family physician's place and given a plaster. Family physician says की डॉक्टर काय करणार, एक्सरे मध्ये मला दिसतंय, मी त्यांना एक्सरे पाठवलं, ते सांगतात प्लास्टर करावं लागेल, हेअरलाईन आहे, काय प्रॉब्लेम नाहीये, मी करू शकतो. डॉक्टर तर त्यांच्या क्लिनिक मध्ये पण तेच करणार आहे, माझ्या क्लिनिक मध्ये येऊन करू द्या. Whatever money is, I will share. So consultant feels I will not lose patient. माझ्याकडेच येणार. Family physician feels my patient will remain with me. But be very careful in advising and writing of your procedure. Follow up advice, do's and don'ts. Otherwise, if this patient lands up with a problem, ultimately the consultant who has done will be asked questions. The family physician will say, I have asked an orthopedic surgeon, he gave, and it was supposed to be done. He thought it can be done here, he did. Second thing, what sir has told, again, very important. How do you check that qualification? Be very open. Ask for your qualification of the consultant you are visiting. We have a matter in Mumbai where a masala seller from Gujarat practiced for 2 years as an orthopedic surgeon, did 28 surgeries, spine surgery also. And now the police is going and harassing the hospital owners. And I say they are right. What do you do of the masala seller? You can't suspend his license. He doesn't have a license. He has earned a huge amount of money. The police is now harassing also the instrument supplier who has supplied the implants. कि बाबा तू तर विचारायचं त्याचा नंबर. आता इंस्ट्रूमेंट सप्लायर काय म्हणतो, ओनर आमचा जुना आहे, तर हॉस्पिटल ओनर ने मेरे को बोला कि इसको देना है, मैंने आकर दे दिया. अरे but registration number, he was giving also a registration number. And we have such a good MMC app where you just go and type the name and you get all the qualification, the registration number. I told to the municipal corporation where that matter happened कि सर तुम्ही टाका ना, आणि तुम्ही सगळ्यांना तुमच्याकडे कन्सल्टंट असो, BMC, MBMC, कॉर्पोरेशन, प्रायव्हेट, सगळ्यांना सांगा तुमचे रिन्युअल सर्टिफिकेट सबमिट करायला, त्याच्यावर फोटो आहे. And why all our allopathic doctors don't have a know your customer असतं तसं know your doctor आपल्या ओपीडी मध्ये डिस्प्ले करा. आपली फोटो, आपले डिटेल्स. पेशंट सिटिंग वेटिंग मध्ये तुमचा फोटो बघतो, तुम्हाला बघतो, आणि आतमध्ये पण तुम्हालाच बघतो. नाहीतर काय असतात मल्टी स्पेशालिटी ओपीडी मध्ये, मी जाऊन सांगितलं अशोक शुक्ला सर आहे, ते सांगितलं पेशंटला कुठे काढतं, चेहऱ्यावर कुठे लिहिलंय, त्यांना वाटतं हेच कन्सल्टंट आहे. 4 व्हिजिट नंतर माहित पडतं की ते लोकम होते, आपले डॉक्टर बाहेर गावी गेलेले, हे मेन डॉक्टर आहे. Treatment चालू आहे. And these are facts which are happening because of communication issue. So please take this very, very seriously, because these all hospital owners are now paying huge amount because those patients who have been operated has been approached by police officer and said that a quack has been operated on you and everybody is having backache. Or the backache so everybody feels because a quack has operated, my operations failed, and they all have started now filing cases. It will come on. It is already started. That masala seller is behind bars. Masala seller is behind bar. IV fluid. Lot of time family physicians admit on paper maybe half an hour, 1 hour, 2 hours. OPD संपण्याच्या अगोदर 1-1.5 वाजता OPD संपणार, 1 वाजता आलं, कमजोरी है, weakness है, loose motion है, we run the IV fluid. Be very, very careful. This can be very, very dangerous. Either if you are starting, then follow all the lines, or say कि बाबा मी आता बंद करतो, तुम्ही त्या डॉक्टर कडे जा. Neither, because there was a issue where a severe loose motion patient died in a family physicians, and then he gave cause of death diarrhea. आता डायरियामुळे तुमच्याकडेच डेथ झाली, 2 तास तुम्हीच मॅनेज करत होते. आणि तुम्हीच डॉक्युमेंट करत होते डायरियामुळे मेलं आणि डायरियाचं ट्रीटमेंट मग तुम्हीच देत होते. नाव पेशंट एलेज्ड, सरच सांगतात डायरियामुळे एक्सपायर झालं, पण ट्रीटमेंट सरच करत होते. नाव ही हॅज टू जस्टिफाय हाऊ सिव्हिअर द डायरिया वॉज अँड वाय ही डिडंट ऍडमिटेड इन द हॉस्पिटल. So be very, very careful. Investigations, resuscitation. See, lot of time now we are doing small procedures in our OPD. आम्ही आधी CLW करायचो, काय होत नाही, आम्ही आधी करत होतो. कॉपर्टी पण मी लावत होतो. माझी ट्रेनिंग झाली आहे, मी 30 कॉपर्टी कॉर्पोरेशन मध्ये लावलं आहे, मला माहिती आहे पोझिशन इथे देतात, माझी सिस्टर एक्सपिरियन्स आहे. व्हॉट विल हॅपन इफ द पेशंट हॅज अ व्हॅझोवेगल शॉक? आर यू इक्विप्ड? मी एक कोर्स केलाय, फेलोशिप केलाय, मला कॉस्मेटिकचं नॉलेज आहे, मी हेअर ट्रान्सप्लांट पण करू शकतो. मी दादरला एक फेलोशिप केली आहे फॅमिली फिजिशियन MBBS झाल्यानंतर, आणि आय हॅव लर्न. आणि इफ द पेशंट हॅज एलर्जी टू द प्रोटीन, what you have, do you have a method to resuscitate this patient? No. Then what you will answer to the court? Court will ask you, do you feel there is a chance of anaphylaxis? You will say yes. Then what precautions you took? You are yourself only answering. So be very, very careful. If you're doing these procedures, then be fully equipped. Do CPR training, keep your resuscitation kits, emergency tray, sagada oxygen. How many family physicians have an oxygen? You have to. Lot of time we get family physicians or get patients or OPD consultant get patients from another consultant. They mother येऊन सांगतात, ओ मेरा बच्चे को ना नेबुलेशन बोला है, ओ pediatrician चला गया, पेपर लिखा है, and we give. What will happen if there is some problem? If there is a bronchodilatation, anything happen? Are you equipped to manage? The patient will feel तुम्ही चुकीचं औषध दिलं. So be very careful when you are following instructions of other doctors. Lot of time there are other consultants who have said, ये injection तुम नजदीक के family physician से ले लो, और मालूम पड़ा 6 महीने पहले का prescription चल रहा है अभी तक. तो be very careful whether you are. I always tell, call that consultant. We have, sir, ये patient है, ये ऐसा ऐसा देना है. And if you feel this can give a allergic reaction, tell them, बाबा माझ्या बिल्डिंग मध्ये कोणी हॉस्पिटल नाही, वरती एक हॉस्पिटल आहे फिजिशियनचं, तिथे ICU, तिथे जाऊन इंजेक्शन घे. Patient will respect your decision. And patient will be very happy. Then ultimately, and if you tell की असं असं होऊ शकतो आणि तुमच्या पेशंटला रिस्क असू शकतो, patient's relative feel you care for my patient and he will come to you more. आणि ते तुमच्याकडे आणखीन 4 पेशंट पाठवणार. डिस्प्ले क्वालिफिकेशन, CCTV installation. Violence documentation तुमच्याकडे नाही. There was a family physician in Bhinder who got a trauma. तो आला आतमध्ये, थांबला कोविडच्या टाइमला, आतमध्ये आला, 10 to 18 injuries by BP instrument. Whatever his reason for theft was, continuously hit it, continuously. She had so many CLWs. We rushed to the hospital. CLW sutured, and Mira Bhinder police arrested him from Kolkata before he was going towards Bangladesh. We made it that he has to be arrested. This is because of COVID. He told कि मला एक certificate पाहिजे, RT-PCR करायचं आहे, मला दुबईला जायचं आहे, and he waited till all the patients go, and he was sitting outside on a Sunday. He know कि कमी लोक आहेत. CCTV helped because the vehicle what they had used, they were able to trace, and they found out that this person is a frequent offender, and they arrested. CCTV helps. Violence also helps. POSCO, you have now 12, 13, 15, 16-year-old girl. अरे ही तर जुनी पेशंट आहे, लहानपणीपासून दाखवते. मी 28 वर्षापासून प्रॅक्टिस करते. ही माझ्याकडे आई येत होती, आता मुलगी येते. आली काय, मला ब्रेस्ट मध्ये थोडी स्वेलिंग आहे, एक्झामिन केलं. शी माइट नॉट अंडरस्टँड गुड टच, बॅड टच. शी माइट मिसइंटरप्रेट. See that you have a female attendant. Better her mother is also there. Why? काय घाई आहे तुम्हाला? Because the moment she goes home and says the history, आई विचारणार काय सांगितलं डॉक्टरने, बोला सब नॉर्मल है, बट बार बार चेक किया. Miscommunication occurred because you tell everything is normal. Lot of time we as a gynecologist get girls around 12 to 14 years where breast nodule is growing and the mother is conscious. She comes and says ते left थोडा मोठा आणि right थोडा छोटा आहे, तुम्ही बघून घ्या ना. अरे मी सांगितलं नॉर्मल आहे, तुम्ही बघा एकदा. Because she's worried. And at the family physician also level, this can happen. Be very, very careful when you are touching any girl or boy below 18-year-old. You might land up with some problems. If you are not taking all those precautions, who is the attendant? And you should write on the paper, 16-year-old girl came with history, accompanied with so-and-so. Legally, person who is accompanying becomes a legal guardian. And he should be a major, above 18 years old. So this is something important. Lignogen sensitivity test, how much people before doing CLW check. And suddenly patient might have borderline investigation. If you're doing some small procedures, are you doing some investigations? Your expertise, your documents should, everybody would have seen this movie. End tak police pareshan tha ki body kidhar hai. Everybody was speaking the same line. So your papers, your staff, your receptionist should be speaking the same thing. What you have done, there should not be any discrepancy. Nothing will happen to you. You have done with good intention, court will always protect. This is the best slide. Chairperson will take home message. So good doctor-patient relationship. If you have a good doctor-patient relationship, normally patient don't file case. Dr. Navrange sir would have seen. Ultimately, patient files case against doctor. Mala dukhawla mi ya doctor sodnar nahi. He is not much interested in money. Otherwise, there will be no complaints in corporate. There are a lot of time people complaining. They say, "Mala ya doctor la jail mein rakha mala paise nako." That is because he has got hurt. Because your doctor-patient relationship is very poor. You should make the patient feel what you're giving the treatment. And when the things happen, the patient should feel, doctor माझ्या बरोबर सांगत होते एंड पर्यंत मी प्रयत्न करतोय, चान्सेस भरपूर कमी आहे, पण आपण शेवटीपर्यंत लढणार. He should feel. आपण काय सांगतो, काय नाही मी तर हे प्रोसिजर मी किती वर्षापासून करतो, 1000-2000 केले काय होत नाही, आणि that patient only. So you have to see that this is a procedure which has its known complication. I tell my patient, अपन हवा भी लेते हैं ना, pollution है ना, पानी पीता है, लूज मोशन हो सकता है, अपन क्या करता है, प्रिकॉशन गर्म करता है, एक्वागार्ड यूज करता है, हम लोग भी सब करता है, गारंटी कैसे देगा? मैं 100% करेगा मेहनत, बट आउटकम तो भगवान क्या. पेशेंट अंडरस्टैंड्स कि बरोबर है, डॉक्टर बोल रहे हैं बराबर है, अपन पानी पीता है, कॉर्पोरेशन से आता है, अपन टैक्स भरता है, तो भी लूज मोशन हो सकता है, पाइप में लीकेज हो सकता है, अपन गर्म करता है, aquaguard use. So you have to have a good rapport and explain the patient in the language they understand. Avoid loose comments. संडे तो आज बसला नाही आहे, त्याचा पेशंट माझ्याकडे आला, आज मी दाखवतो आपको ये दवा ये दवा तो काफी पुराना जमाने में लिखता था, अभी नया आ गया, अभी आउटडेटेड है. झालं. Consultant jousting. Dr. Santosh Kakade sir will always, he tells 70% of cases he sees in consumer forum is because of consultant jousting. One doctor has commented loose, the patient is blank. त्याला माहित पडतं असं मी नाही सोडणार, माझं जुनं डॉक्टर आहे. अँड पीपल ऑलवेज से माझं जुनं पेशंट आहे का कंप्लेंट नाही करणार, जुना सर्वात आधी करतो. त्याला काय वाटतो, आपण देवाकडे जातो आणि काय सांगतो, 25 वर्षापासून ह्या देवाचं मी नवस केलं, माझं इच्छा पूर्ण झाली नाही, आपल्याला फील होतो. तसंच पेशंटला काय वाटतं, 20 वर्षापासून या डॉक्टरला दाखवतो मी, 20 वर्षापासून, आणि ह्या डॉक्टरने माझ्याबरोबर असं केलं, आय एम नॉट गोइंग टू लीव हिम, बिकॉज मोर faith. More the faith is, more the expectation is, and more the expectation is, if you don't manage, more severe the relative is going to come against you. Follow all the guidelines. If you follow all the guidelines, try to follow at least all the guidelines. All law of land, वो 2 लाइन बहुत भारी है, सब law आ गया उसमें. Update your knowledge. Update your knowledge. I always tell, attend programs, update your knowledge, upgrade your knowledge. In a Delhi conference around 12-15 years before, I told everybody sitting here who might be having iPhone, but ask them whether they can know all the functions. Who's paying your money? Patients. And what you're giving? City Hall. Update. Upgrade your knowledge. Ultimately, patient is funding your LED 46 inches. आधी पण कलर टीव्ही मध्ये ते दिसत होतं ना, अमिताभ बच्चन तसंच दिसत होता. आधी आपलं कॉमन होतं, नंतर LCD आता LED आलं. आपण तर वाढवत चाललो ना. ना, give, they will be happy. Update and professional indemnity. Follow law. Indemnity policy is the must, and people have so low amount of indemnity policy. I say you upgrade your car, you upgrade your mobile, keep increasing your indemnity policy sum assured, and never have a gap between two sum insured. Never by mistake also tell break हो देना. If you follow all those instructions, peaceful practice. अरे काय होणार, आपण तर चांगलं केलं, पेपर व्यवस्थित आहे, आपलं मन साफ आहे, कोर्टात जाऊ, नाही कन्व्हिन्स झालं पुढच्या कोर्टात जाऊ, नाही कन्व्हिन्स झालं पुढच्या कोर्टात जाऊ, हारला तर इंडेमिनिटी पॉलिसी पैसे भरणार, आपण प्रॅक्टिस करायचं, स्ट्रेस कशासाठी घ्यायचं. बट फॉलो रूल्स ऑफ अँड टेक अ इंडेमिनिटी पॉलिसी. प्रॉब्लेम कुठे होता, आपण घेत नाही, आणि आपल्याला असं वाटतं की आपलं लाईफ इझी आहे, तसं नाहीये. थँक्यू एव्हरीबडी.
थँक्यू डॉक्टर शुक्ला. It was a very action-packed lecture, and actually, you said that I'll be talking 10 minutes less, but you have talked 10 minutes more. But since people are attentive, I didn't disturb you.
केळकर हॉलमध्ये लगेच फोन करा. So thank you, sir. I request our President Madam, Dr. Meenakshi Deshpande, to come on the dais. And we'll call Dr. Navrange sir. Dr. Navrange sir, please come on the dais to felicitate, and chairpersons to judge. Hello. So please be comfortable and come at 2 o'clock. You can go and have lunch in Kilkar Hall. Separate arrangement for faculties and delegates. Yeah, chairperson. Hello, hello. And the right side for the faculty and left side for the delegates. And I request Dr. Meenakshi Deshpande madam to felicitate our chairperson, Dr. Mohan Joshi sir, and Dr. Uma Wankhede. So at sharp 2 o'clock we'll start.